Yeah, absolutely. Wait, please, my lord. My lord, I am preferring this present petition for transfer of a title suit matrimonial from the Court of District Judge Jorhat to Tinsukia, my lord. The fact of the case is that my marriage was solemnized at Tinsukia, my lord. Both registration of the marriage was also there.
As right for transferring title suit within bracket M number 77 of 2025 pending before the Court of Learned District Judge Jorhat to the Court of Learned District Judge Tinsukia. Mr. Sensual Learned Counsel for the petitioner submits that the petitioner is the wife of the respondent and their marriage was solemnized when?
In Tinsukia, my lord.
Solemnized at
17/1.
Tinsukia on 17/1/2023.
23.
And thereafter, they used to they live together as husband and wife in a matrimonial home at Jorhat.
Jorhat, my lord.
Jorhat, and thereafter, a marital discord surfaced, and presently the petitioner is residing at her parental abode at Tinsukia. And Mr. Sensor further submits that 3 other proceedings are pending before the petitioner and the respondent hearing. And
Tinsukia.
the present proceeding is pending before the Court of Learned District Judge at Jorhat, and she has no means to contest the said proceeding at Jorhat. And as such, the Learned District Judge Jorhat decided to proceed with the case ex parte as she could not appear before the court, before the Learned Court. And under such circumstances, Mr. Sensua contented to transfer title suit number so and so pending before the Court of Learned District Judge Jorhat to the Court of Learned District Judge at Tinsukia. The submission of Mr. Sensor needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post, speed post, and also by usual process, which I know come today. And considering the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of title suit within bracket M number 77 of 2025 pending before the Court of Learned District Judge Jorhat stands state till returnable date list after 4 weeks.
Deeply obliged, my lord.
That is for hearing under order 41 due to CPC. That number 1.
May please, your lordship. My lord, we have filed the amended memo of the appeal, my lord. My lord, in page 8, the substantial questions of law. My lord, the first question is, my lord, whether the learned first appellate court was correct in deciding the issue number 4. Page 8, my lord. Date of the amended memo of appeal. Amended function.
Yes.
My lord. And the first question is, my lord, of whether the first appellate court was correctly decided the issue number 4, holding a view that the defendant number 2 is a bona fide purchaser entitled to benefit under section 14 of the Transfer of Property Act, ignoring the admission of the defendant number 2 that the defendant number 1 has told her that the defendant number 1 has purchased the land from the plaintiff. But the defendant number 2, in her own admission, also stated that he never asked the sale deed, never made any query either before the defendant number one, the vendor, or the plaintiff, who is the actual owner of the land. So she is not, this decision holding that she is a defendant number two is a bona fide purchaser entitled to benefit under section 41 of the Transfer of Property Act is wrongly decided, my lord. This is the first point.
What question of law is involved here?
My lord, the question of law is whether the defendant number two is entitled to the benefit under section 41 of the Transfer of Property Act, that she has taken, he has taken reasonable care before purchasing the land and acted bona fide. This is a question of law, man. Section 41 is given the benefit as a bona fide purchaser. This is the one of the important question, my lord. The issue number 4.
Whether any issue was framed by the trial court on this point? Sorry, first appellate court and the trial court?
My lord, the issue was framed by the trial court, and the same issues are also discussed by the appellate court. But without discussing the evidence, my lord, lordship may kindly have a look at page 17. My lord,
17
issue
of
number
the
4. Issue number page 17, my lord. Issue number 4, whether the defendant number 2 is entitled to protection under section 41 of the Transfer of Property Act.
Hmm.
This was the issue, my lord. As
How the trial court has dealt with this issue?
trial court has dealt with that, the defendant number did not ask the sale deed from the either from the plaintiff or from the her vendor, the defendant number 2. So she is not entitled the benefit. And the appellate court, this has been reversed, my lord, without discussing the evidence, my lord. If lordship wants to see the evidence, my lord, I can say that certificate copy you are having.
How the appellate court has dealt with this issue?
My lord, Lordship will find, my lord,
Paragraph
appellate court
number?
judgment page 41. And issue has, number 4 has been discussed,
Paragraph number?
my lord. Issue in type appellate court, my lord, issue number 4 has been discussed in page 68.
Page?
68. But the appellate court has not discussed the evidence, my lord. Only the admission of the DW1 and DW1 and defendant number 1 and defendant number 2. Their admission has not been discussed.
There was a one cell deed
My lord.
with which was exhibited as exhibit 2.
My lord, that was
And that cell deed was not challenged by you.
my lord, that cell deed, my lord, my lord,
Hmm.
my lord, that has been challenged, my lord. Lordship may kindly
No,
kindly have a
you say
look
it
at,
is
kindly have a look at,
number-
my lord, my prayer in the plaint, my lord. Para in prayer portion part 3.
Your plaint is at page number
My lord, plaint is at page 86 onwards.
86.
86 onwards. They sealed it, my lord, at prayer portion at page 90. See, their sealed it has been challenged, my lord.
Then how the appellate court has observed in paragraph
lord,
number 36?
My lord, without even discussing the own admission of the DW1 and DW2, my lord. And that right court has rightly decided, my lord, on the point.
And the next substantial question of law?
My lord, second question of law, my lord, at page 9, that whether the appellate court was correct to hold the defendant number 1 as an ostensible owner. Although the real owner, the appellant plaintiff has neither given any implied or express consent to act as a ostensible owner. More so, the transferor, the defendant number 1, has sharply contradicted. Once he said that he purchased the land from the plaintiff. In another, he also said that he purchased the land from father of the plaintiff, but no sale deed has been produced. This is the second question of law. How he can be treated as an ostensible owner and benefit of under section 41 of the Transfer of Property Act can be given, my lord.
Let there be only one substantial question of law.
My lord. Discuss to the assent.
Heard, Mr. Sigdar, learned
Yes,
counsel
yes,
for the
yes.
appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 24/9/2025 passed by the learned Civil Judge Senior Division Nagaon in title appeal number 1 of 2024. It is to be noted here that by the impugn judgment and decree dated so and so, the learned First Appellate Court has allowed the appeal by setting aside the judgment and decree dated 30/8/2023 passed by the learned Civil Judge Junior Division number 2 Nagaon in title suit number 103 of 2012. It is to be noted here that by the impugned judgment and decree dated so and so, the learned trial court has decreed the suit of the plaintiff. Where is the memo of appeal and the grounds mentioned therein, and also where is the suggested substantial question of law? And the impugned judgment and decree dated 24/9/2025 passed by the learned First Appellate Court in title appeal number 1 of 2024, and also the judgment and decree dated 30/8/2023 passed by the learned trial court in title suit number 103 of 2012. The second appeal is admitted on the following substantial question of law. Whether the learned First Appellate Court is justified in reversing the judgment and decree of the trial court dated 30/8/2023 by reversing the finding recorded by the learned trial court in respect of issue number 4 by holding that the defendant number 2 is a bona fide purchaser and entitled to the benefit of Section 41 of the Transfer of Property Act 1882, ignoring the admission of the defendant number 2 that her vendor, defendant number 1, has purchased the land from the plaintiff. The court may also consider framing of further substantial question of law if the same is found to be necessary at the time of hearing, after notifying both the parties. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Justice shall call for the record from the learned courts below. Place the matter after 4 weeks.
My lord, I have a miscase, my lord.
Whether execution case is filed,
No, as per our information, my lord, no execution.
we'll consider it on next date.
My lord,
Heard Mr. Sigdar, learned counsel for the applicant. This interlocutory application under Order 41 Rule 5 read with Section 151 of the Code of Civil Procedure is preferred by the applicant for staying operation of impugned judgment and decree dated 24/9/2025, passed entitled appeal number 1 of 2024 by the learned civil judge senior division, Nagaon, by allowing the same and setting aside the judgment and decree dated 38/8/2023, passed entitled suit number 103 of 2012, passed by the learned civil judge junior division number 2, Nagaon. Let notice be issued to the respondents returnable in 4 weeks. Is that be taken by registered post with AD and also by usual process within a week. Place the matter after 4 weeks.
Deeply obliged, Lord.
May I please, Your Lordship,
Yes.
as per your honorable court's order, appeal memo I filed. I am appellant, Lordship. Correct.
It is on page 6, Lordship. My substantial questions of law as per honorable court's order, appeal memo, amended appeal memo, Lordship. Here I have mentioned 3 substantial questions of law, Lordship.
No, your substantial question number 1 is confusing.
Lordship, my substantial question is on Moneylenders Act, Lordship. Assam Moneylender Act, 1934, Lordship.
Hmm.
This issue was not raised by even the Munship or by the Land Appellate Court.
Whether
Whether-
whether you have taken such a plea in your written statement.
Lordship, no.
Your written statement is part of the record.
Yes, Lordship.
Page number.
Yes, Lordship. This is page 45 to 47, Lordship, of the appeal. Will memo, Lord. Page 45, 47, Lordship.
Where you have taken the plea.
This play I have not taken, Lordship. This part I have not taken.
You have not taken.
Moneylender, this been filed by.
Then why the
other-
will frame issue on that point?
Lordship,
In absence of your pleading, how the trial court will frame issue?
no, that issue was not framed by even the trial court, Lordship. That Moneylender
No,
Act.
if it is not there in your
Then I-
pleading, then
I'm on
why the
second-
court will frame the issue?
I am on second and third, Lordship. My substantial question is that actually the validity of the case is not there. Because under section 7D whether he has to be a moneylender under, he has to be a registration certificate, Lordship. Then only he can lend money. That issue was not raised, Lordship. Because it is an invalid case. He cannot lend money also, Lordship. That issue was not raised by the learned appellate court, not the trial court. Advocate did not take that issue, Lordship. Did not take the plea in the written statement. Trial court advocate. There is a mistake done by the advocate, Lordship. I think so. He has not taken that plea. He should have taken this plea, Lordship, in a written statement. So he has done this, I think, mistake by not taking this plea.
Okay, we'll pass the order. Heard Mr. G. Das, learned counsel for the appellant. Order reserved.
Item 3 for orders.
May I please, Lordship?
Mm.
Lordship, as per office note, service is not complete. So I may be allowed to take fresh step through speed post, Lordship.
This IA is for what purpose?
Lordship, for substitution, Lordship.
Substitution.
Substitution or respondent number 4.
So today we have to pass order in the IA.
Yes.
Lordship. Condonation petition is there, Lordship, along with that.
The delay is also not condoned.
After their appearance only, the delay petition will be heard, Lordship.
No. There is delay in filing this substitution petition.
Substitution.
So the section 5 petition has to be disposed of first. Only thereafter the question of substitution will arise.
Lordship.
In this delay computation application, notice was issued.
Notice issued.
Notice.
Notice.
To the 23/8.
You want to take fresh step.
Lordship.
Heard Mr. A. Islam, learned counsel for the applicant, and Mr. Z. Bhardas for respondent number, opposite party number
2 and 3.
1, 2, and 3. Office note dated 13/2/2026 indicates that neither ready card nor unserved notice issued in respect of respondent number 4A, 4B, 4C have received back by the registry, by the section. Mr. Islam submits that he may be permitted to take fresh step upon the respondent number 4A, 4B, and 4C. Pair allowed. Step be taken by registered post with speed post and also by usual process, which we will come today. Place the matter after 4 weeks.
Item number 4.
Yeah, please, Lordship. Lordship, in this case, I have filed an IA. It is not on record, my lord. I have
IA
filed it
for?
as IA for impleting the legal errors of respondent number 6. On last occasion, it came to my knowledge that the respondent number 6 has expired. I filed the IA. On yesterday, I filed and I have also served a copy.
Okay, it is not on record.
Not on record.
The shortcut to bring this same address.
Okay.
That can be disposed of. I have obtained the instructions.
Heard Mr. Bhardas, learned counsel for the petitioner, and Mr. Potter, learned counsel for all the respondent
Respondent number 6.
except respondent number 6.
The decision.
Except respondent number 6. Mr. Bhardas submits that respondent number 6 suffered demise and he filed one application, interlocutory application for bringing on record the legal representative of the respondent number 6, but the same has not been placed on record. Accordingly, it is provided that registry shall list the matter on Friday,
Lordship, can it be on 25th, subject to a lordship convenience?
25th. Okay, all right. 25th. Along with the interlocutory application filed by the petitioner.
The interim order passed earlier.
Interim order passed earlier shall continue.
Item
Number 5.
The left hand side is the orders column. As there is an existing IA petition, 520/2024, under order 41 rule 27. So that petition under order 41 rule 27 cannot be heard without the appeal being heard, along with the appeal hearing is to be heard.
No, on the other day you have submitted this. Based on which this order was passed accordingly, taking note of the submission of learned counsel for both the parties, it is provided that SSL lists this IA along with RSA on 17 to 2026. This for hearing.
Loco, this honorable court will like to hear the matter, hearing, final hearing.
Yes,
All right, in that case.
can we hear this application in isolated way?
Yes, Lordship. So if you like to
It
hear.
has to be along with the appeal.
Appeal hearing.
So today, you are not ready.
Actually, I was little under confusion whether this will be. Because it has come with in the RSA column, there is no such mention of hearing. In RSA, the order is not passed in the RSA. It was only passed into this one.
No, now you tell me, are you ready to argue the matter or not today?
A date may be fixed, Lordship, in this case.
Yes, Mr. Day.
Last order is clear by Lord.
This is of 2017 matter.
Lordship.
Okay. Suggested date.
Twenty-seven. 6.
Lordship, that
17. Yes.
Yeah.
10 or 17.
10 marks. Okay. Heard Mr. Bhagavati, order, you take down the order in RSA. Heard Mr. Bhagavati, learned counsel for the appellant, and Mr. PC Day, learned counsel for the respondent. Resolution lists this matter for hearing on 10th of March, along with the IA number
520/1
520 of 2025.
24.
25.
20. Lordship.
I have dimensions. I'll not play. I'll not play the appeal.
Okay. This IA is filed by you.
I is filed by others, my lord, the respondent.
I am for the appellate. They have now filed the I questioning the maintainability of the appeal. The appeal is admitted, but ultimately legal question I have seen. Appeal is not actually maintainable. I am not pressing the appeal.
Okay.
Response of the appeal.
Okay. So you want to withdraw the appeal?
I am not pressing. Not pressed.
Okay. Okay. RS.
Yes, sir.
Mr. Nath, I don't know who appeared before the court on the day of admission. It ought to have been pointed out to the court that this is under such and such
Yes.
act.
I have seen it subsequently. Logic.
Heard Mr. D. Nath, learned counsel for the appellant, and Mr.
GJ Swagya, my lord.
G.J. Soikia, learned counsel for the respondent. Mr. Nath submits that he may be permitted to withdraw this RSA. Accordingly, taking note of the submission of Mr. Nath, learned counsel for the appellant, this he is allowed to withdraw this appeal, and this appeal stands disposed of on withdrawal. And in IA takedown, in view of the order passing the RSA number 119 of 2026, this IA number 308 of 2026 stands closed.
My lord, one observation, my lord, all interim orders stands vacated.
Okay, interim order,
Interim order dated
if any,
27.
passed earlier, stands vacated.
Logic.
Obliged, my lord.
In his settled position of law.
Yes.
I can say.
There are several decisions of Supreme Court.
Obliged.
Made petition lordship. This IAs were actually filed for correction of the order, but I have received the information that the petition has been dismissed from the service on, and we have received it on 6/2. In view of the matter, this IAs have become infructuous because we have to challenge it afresh. Even though there was a clear order by your lordship that observations was there, the identical parallel proceedings, same criminal and same departmental. It was that maybe observation with a liberty may be given to challenge the same. To challenge the dismissal order, no? Liberty may be given since even
Okay,
but the repetition still survives, my lord, because we have challenged the inquiry report that is still there. Only the IA I have become infraction.
only the IA.
Only the IA repetition still survives, my lord.
Mr. Smith, learned counsel for the
Applicant.
applicant, submits that this IA become infructuous and as such the same may be closed accordingly taking
Malad,
note of
that may be observed, Malad, that-
Mr. Smith. This IA number 312 of 2026.
And liberty may be granted to that observation. My lord, it was this. We have received the dismissal order on 6/2,
No,
and
no,
as such,
yeah, you are going to pursue this WPC or not?
yes, I'm going to pursue the WPC, my lord.
Okay. How about Liberty? No, it
I am,
is
madam.
heritable like submission. Heard Mr. Smith, learned counsel for the applicant. Mr. Sharma, you are here?
Yes.
Mr. Sharma, learned counsel for the opposite party. Mr. Smith submits that during the pendency of this interlocutory application, the applicant has been dismissed from service by the respondent authorities. And as such, he is not going to pursue this interlocutory application, and the same may be closed, granting him liberty to challenge the dismissal order. Fair allowed. Liberty will remain with the applicant to approach this court again by filing appropriate petition. Struck application.
Well, the repetition is
the
survived, huh?
I stance possible. There is another I number
Well,
70
both
of
the
20.
for the correction actually. Both can be disposed of on the same.
Okay, same order in 70.
Well, repetition survives, my lord.
Okay. Heard Mr. Smith, learned counsel for the petitioner. And Mr. U. Sharma, learned standing counsel for the respondent authorities. You have filed affidavit?
Yes, we will file it.
Okay. Mr. Sharma submits that he may be granted some time to file the affidavit in opposition. Fair allowed? Or recessal is the matter after 2 weeks?
3 weeks, man.
3 weeks, after 3 weeks.
Thanks for hearing. File number 8.
May it please your lordship.
Mm,
Lordship may pass over this matter for the time being, lordship.
Okay.
Number 9.
My lord,
So Hazoka, you are for appellant.
I am for the appellant, Mr. Dilip Majumdar, senior advocate. He is appearing. He is coming.
He is appearing for you.
Appellant. I am led by Mr. D. Majumdar.
May I please ask you?
Mm.
In fact, when this appeal was heard at length in the hearing was over. Thereafter, somehow the court felt, considering the facts and circumstances of the case, the honorable court directed the parties to appear before the mediation, so as to enable them to see whether it can be disposed of outside the court.
Mm.
Somehow it has failed. Other side, our client offered 5 times the land, the value of the land at that time, mentioned in the agreement to sell, but they want more than that. So ultimately, there is a report, I think, that the mediation has failed. Entire hearing was over. Thereafter, this only court sent the parties to the mediation.
That's over for the respondent.
Mr.
BD query is a bill.
Can we start the matter?
Yes.
My lord, I'm for the defendant, my lord.
In the
Possibly,
trial court.
yes. Here I'm appellant, defendant. I've lost in both the courts. Facts in brief are like this. The plaintiff admittedly executed an agreement to sell a plot of land measuring about 22 bighas. Now there are two sets of defendants, my lord. I am representing the appeal has been filed by defendant number 1 and 2. So far as defendant number 1 and 2 are concerned, the agreement was for selling 12 bighas of land to them. Remaining 10 bighas, the plaintiff agreed to sell to the other defendants, defendant number 3 onwards. Pursuant to the agreement, my lord, an advance amount was paid. So far as the present two appellants are concerned, their total consideration was 91,000. Out of that, 55,000 was paid in advance. Remaining 41,000 was to be paid at the time of execution of the sale deed. Similarly, so far as the remaining defendants are concerned, defendant number 3 onwards, 3 to 7, I think. In respect of them also, the agreement provided that they have paid some amount in advance and subsequently the remaining amount will be paid. So far as those defendant number 3 to 7 are concerned, the plaintiff case is that they have paid the full amount. But so far as present two appellants before Lordship are concerned, they did not pay the balance amount of 41,000. On top of that, sale deed was executed, parties went there, put their signature. After execution, when they filed the suit, they said that sale deed was not executed, it was a gift deed. In place of sale deed, since the appellant before Lordship, who were the defendant number 1 and 2, the plaintiff's case is that he has taken the initiative to prepare the sale deed, etc. But instead of preparing the gift deed, he has prepared the sale deed. Instead of preparing the sale deed, he has prepared it as a gift deed. But admittedly, the plaintiff vendor received 55,000 in advance, that is there. Prior to that, the agreement to sell that was executed, that is also there. Now, the plaintiff now has filed a suit saying that so far as the remaining defendants are concerned, that is defendant number 3 to 7, they have paid the full amount, and for them also, not one, my lord, more than one deeds were executed, but in respect of them also, some of the deeds were gift deed. Then in the cross-examination of PW1, that is the plaintiff, he says, since I have received the full amount of consideration from them, I have not challenged their gift deed, but I am challenging your gift deed because I have not received the full amount.
No. In case of gift deed, where is the question of payment?
Yes, where is the question of payment? That is correct. If it is a gift deed, there is no question of payment. It's a gift. But fact remains that plaintiff has received advance amount from us and from them also, remaining defendants. So far as they are concerned, since the plaintiffs received the full amount of sale consideration, even if in respect of them some of the deeds were gift deed instead of sale deed, he says, I have not challenged those gift deeds. Meaning thereby that in our gift deed, he is challenging only because he did not receive the remaining amount, that is the balance amount of 41,000.
Hmm.
Now, this is one aspect of the matter, my lord. And the trial court, my lord, decreed the suit, holding that no, it was supposed to be a sale deed and it was gift deed. The defendants themselves took the initiative for the draft and execution and registration of the sale deed. Although we went there and we put our signature, but we did not see it.
Can it be believed?
He's a literate person. He says that I have not seen the document. I put my signature. The
Hmm.
trial court believed that, and trial court decreed the suit, holding that the gift deeds are fraudulent document, accordingly declared void.
Hmm.
Appellate court has gone in a slightly different direction. Appellate court says if you say that there is one undue influence, now the plaintiff's case is that by undue influence the documents were prepared as a gift deed in place of sale deed. But first appellate court said the plea of undue influence, for proving the plea of undue influence, the burden is on the defendant.
Hmm.
Although the plea was taken by the plaintiff, first appellate court says burden is on the defendant, that is us.
How?
The trial court is held like that, I'll show you.
Okay.
First appellate court. Trial court did not go into this question. First appellate court has held that so far as plea of undue influence is concerned, you have to clear that there was no undue influence. Otherwise, I am presuming that there was undue influence. That is the finding of the first appellate court. Now, so far as this appellate court is concerned, the substantial question of law that were framed, Lordship may kindly have a look, because why I am indicating this, my lord, possibly there is a need to frame one or two different substantial questions of law. I'll just make my submission. Before that, your lordship will kindly see the substantial question of law that were framed by order dated 21/1/2009, my lord. Has your lordship got it? Something.
Got it.
Number one, whether in view of clear admission on the part of the plaintiff, as also the recitals in the deeds that the same were executed in sound mind, health, and understanding, the learned lower appellate court was justified in cancelling the said deeds on the ground of undue influence and fraud when there was no pleading of fraud or undue influence by the plaintiff. This is the first substantial question of law. Second one is whether even assuming it to be a case of fraud and undue influence, the learned appellate court was justified in shifting the burden to the defendant's appellants to prove that the transaction was not induced by undue influence and fraud, in as much as the burden of proof is upon the party who seeks to avoid the transaction on the ground of fraud or undue influence. This is because of the finding recorded by the learned first appellate court. And third one is, my lord, whether the learned lower appellate court, without arriving at any finding as to whether the defendants were in a position to dominate the will of the plaintiff or as to the nature of fraud as required under section 16 and 17 of the Contract Act, respectively, was justified in declaring the deeds in question to be invalid. My lord, subsequently, on 18/3/2025, 18/3/2025, when the matter was being heard, my lord, on different dates, it was heard by Honorable Justice D. Barua. On 18/3/2025, Lord will find in the order sheet, my lord, one more substantial question of law was framed in view of the provisions of section 55(4)(b) of the Transfer of Property Act. Whether the learned courts below were justified in decreeing the suit in favor of the plaintiff when it was an admitted fact that the plaintiff had duly executed the deed specifically described in Schedule Q, and the grievance of the plaintiff could have been taken care of by the provisions of section 55(4)(b) of the Transfer of Property Act 1882. This is because in course of hearing it transpired that in terms of this provision of the Transfer of Property Act, once the sale deed is executed and part of the price is paid, the sale becomes complete. and the title passes. But so far as the vendor is concerned, he has a charge over the property so as to claim the balance amount of consideration only.
Hmm. 55%. Section 55. Hmm.
Rights and liabilities of buyer and seller. In the absence of a contract to the contrary, the buyer and the seller of immovable property respectively are subject to the liabilities and have the rights mentioned in the rules next following, or such of them as are applicable to the property sold. The seller is bound, A, to disclose to the buyer any material fact. This is not relevant. Then Lordship may straight go to D. The seller is bound on payment or tender of the amount due in respect of the price to execute a proper conveyance of the property when the buyer tenders it to him for execution at a proper time and place. And this has to be read along with section 54 of this act itself, my lord.
Hmm.
54 defines sale, my lord. Sale is a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. 50, I'm reading 54, madam.
Yes.
Sale
No,
defined,
Mr. Majumdar,
my lord.
you see this second, this fourth substantial question of law.
My lord.
No, additional substantial question
Yes,
of
yes.
law.
Yes.
Relates to section 54, 55, subsection 4, clause B of the transfer of property.
Yes, madam. I'm sorry, madam. I should read 64 1B.
Hmm.
It says where the ownership of the property has passed to the buyer
Hmm.
before payment of the whole of the purchased money
Hmm.
to a charge upon consideration or any transferee with notice of the non-payment
Hmm.
for the amount of the purchase money or any part thereof remaining unpaid, and for interest on such amount or part from the date on which possession has been delivered. My lord, this has to be read actually from the first three words of subsection 4 again. I'll read it again.
Hmm.
It starts with the word in subsection 4, my lord.
Hmm.
The seller is entitled.
Hmm.
Then we go to B, my lord.
Hmm.
That means seller is entitled where the ownership of the property has passed to the buyer before payment of the whole of the purchase money to a charge. He is entitled to a charge
Hmm.
upon the property in the hands of the buyer, any transferee without consideration or any transferee with notice of the non-payment for the amount of the purchase money
Hmm.
or any part thereof remaining unpaid, and for interest on such amount or part from the date on which possession has been delivered. My lord, if I have understood correctly, my lord, subject to your lordship's consideration, this section 55 subsection 4 says,
Hmm.
in a case where the deed has been executed
Hmm.
and title has
Transferred.
passed, then if there is some unpaid amount, my lord, in short, my lord, if there is some unpaid amount, you have got a charge. Vendor has got a charge over the property to the extent of his claim of the unpaid amount.
Hmm.
So in this case, my lord, his case is that, see, there was an agreement. Pursuant to that, you have paid an advance amount of 55,000 and balance amount of consideration of rupees 41,000, which you were supposed to pay at the time of execution of the sale deed, you have not paid. If his case is that, see, because of this, I am not going to sell. It is another thing that whether such plea can be entertained or not, but had there been a plea or his specific case, let's say I am not, now I've decided not to sell, then the matter in my humble submission may or could have been slightly different. But here is a case, by his conduct and his admission in the cross-examination, he is still maintaining that, see, I have not challenged other gift deeds similarly executed in favor of the other defendants because they have paid the full consideration money, and although there is a gift deed in place of sale deed, I am not challenging those. Meaning thereby that he had all the time intention to transfer the property in my favor. Only thing is he is agreed by non-received or non-payment by me of the balance amount of consideration. This is one. Secondly, my lord, there is an agreement to sell. You are not saying today, say, see, since I am not selling, I pray for a decree also for declaring the agreement to sell, so far as you are concerned, to be void. That is also not his prayer. And thirdly, my lord, it is not his case in the entire plain that, see, I have taken 55,000 from you as advance. Now I am not going to sell. Now I am refunding you that balance advance amount of 55,000. That is also not his case. This is how the this honorable court earlier said that, see, your intentions are clear. Supreme Court says nature of the document is not important. What is important is what is the intention of the parties. Vendor wanted to sell, buyer wanted to purchase. Vendor's case is that they have not received the balance amount of consideration. Assuming for the timing is, my lord, that the findings are correct. Although present appellant before your lordship, who were the defendants, their stand is that we have paid the full amount. You wanted actually some more. That is why you have filed the case. It is their case. Assuming for the timing that the finding of the learned trial court that no, balance amount was not received. Even then, you having received the 55,000 in advance, you having not prayed that you want to refund it, you have clearly through your admission in the evidence, making it clear that you have challenged my document because you did not receive the balance of no consideration, and the agreement to sell is valid even till today. And so far as possession is concerned, my lord, that is why I said maybe there may be a requirement of framing one more issue, or if your lordship permits me, I'll argue that. There's one more issue. The lordship is aware, my lord, in terms of specifically the proviso to section 34 of the Specific Relief Act. If the lordship may just have a look at section 34 proviso.
No, here the plaintiff has prayed for consequential reliefs,
No, my lord, they have not prayed.
not paid.
No, that is what I'm saying. They have only prayed for confirmation of possession.
Where is the plaint?
Well, plaintiff, your lordship will find.
Page 80, my lord.
Starts from page 80 and prayer is at 93, my lord. Lordship has got page 93, my lord. First prayer is a core. The decree be passed confirming right, title, and possession of the plaintiff over the land described in the schedule, be confirmed his position thereon. That is his prayer. So far as possession is concerned, he is not praying for recovery of possession. He is praying for confirmation of possession on the ground that, according to him, the plaintiff is in possession of the land. Now, in the cross-examination, my lord, the plaintiff has clearly admitted that possession was handed over.
Okay.
Now, in that view of the matter, my lord, the proviso to section 34 will come in. Proviso says, I'm reading section whole of section 34, my lord. Any person entitled to any legal character or to any right as to any property may institute a suit against the person denying or interested to deny his title to such character or right, and court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. Your lordship is aware, your lordship is referring to those judgments which says that if you do not pray for consequential relief of recovery of possession, your suit will not be maintainable if you are not in possession. Well, there is one development only. The earlier judgment of the Supreme Court said the suit will not be maintainable in terms of proviso to section 34 if you did not pray for consequential relief. In a subsequent judgment of the Supreme Court, that Akkamma's judgment, the Supreme Court has held, maybe for the first time, that entire suit will cannot be said to be not maintainable. Yes, So far as the decree of recovery of possession, that cannot be granted, but declaration of title can be granted, and suit cannot be said to be not maintainable. This is the latest judgment. Earlier judgment, Supreme Court said that no, the suit will not be maintainable because it will be hit by the proviso to section 34. But in subsequent judgment, it has been clarified that Akama's judgment, my lord, that no, suit will be maintainable. Declaration of title can be also decreed, but then recovery of possession cannot be granted.
Can you give the citation of that?
Yes, my lord. That is 2025,
Yes.
3 SCC 513. It no, is it? Akama judgment. I'm sorry, my lord, not this judgment. It is Akama judgment I'm giving, my lordship. I'm sorry, man. This is 2021. I'm sorry, man. 2021, 18 SCC, page 371.
Okay. Yes.
And then by saying so, the Honorable Supreme Court in paragraph 26 says, maybe such a declaratory decree would be non-executable in the facts of this case, but for that reason alone, such a declaration cannot be denied to the plaintiff. Declaration can be made.
No, here,
My lord.
there is a prayer for confirmation of the possession.
My lord, recovery of
But
possession
it is, the word recovery is not there.
recovery is not there. And because, my lord, the plaintiff, according to the plaint, my lord, is in possession of the land. But in the cross-examination, he admits that possession was delivered to the defendant.
Hmm.
And so far as finding of the learned court is concerned below, my lord, finding is very vague. There is no clear finding that the plaintiff is still in possession of the land. That suffers from perversity, my lord, because the evidence is very clear, and that part of the evidence was not taken into consideration.
Hmm. Okay, we will resume after 5 minutes.
My lord.
Okay.
A few paragraphs from the trial court judgment. In this paper book, lordship will find page
number?
page 16, my lord, paragraph 12. My lord, so far as facts are concerned, my lord, I have already narrated.
Yes, yes.
I need not read those
Not necessary.
paragraphs, my lord, yes. Straight with the issues that were framed, my lord, page 16, lordship will find.
Page 16.
Page 16. At the bottom, paragraph 12, my lord. Para 12 at the bottom, my lord.
Yes.
Last line, whether there is any cause of action for the suit. Then next page, whether the suit is maintainable in its present form, whether the plaintiff has right title and interest and possession over the suit land. 4, whether gift deed number so and so, 3 gift deeds were obtained fraudulently from the plaintiff and liable to be cancelled. 5, whether the suit is barred by waiver, estoppel, and acquiescence. Whether the suit land is under possession of the defendant number 1, 2. And now paragraph 14 below, my lord. Issue number 3, 4, 5, and 6 were discussed together. Para 16 at page 18, my lord. It is an admitted fact that the suit land originally belonged to plaintiff Sri Dinanath Borua. This fact has nowhere been rebutted or controverted either by the defendants number 1 and 2 or by pro forma defendant number 3 to 7. It is the categorical averments of the plaintiff both in this plaint as well as in his deposition in court that suit land measuring 12 bighas under so-and-so moja of Sitolmari and Pamila Jarani Hisam belongs to him and under his possession. The land under so-and-so consists of 3 pattas, namely patta number so-and-so. In all these 4 pattas, therefore, all these four pattas, the total land is 22 bighas, 3 katas and 15 leches. But out of these land, the suit land is only 12 bighas. According to the plaintiff, he entered into a contract with defendant number 1 and 2 along with other pro forma defendants for sharing these entire 22 bighas, 3 katas and 15 leches of land. And for this purpose, he executed a bainanama with them at a consideration of rupees 1,82,000 at sub-register office, Nagaon on Swenso, and received 80,000 as advance from them. On 1,399, another amount of 20,000 was paid to him by the 7 intending purchasers. However, out of 1,82,000, the balance of rupees 82,000 remained to be paid by them. It is to be noted that the consideration money for the aforesaid land was fixed at rupees 8,000 per bighas. This averment and deposition of the plaintiff has been corroborated by the evidence of PW5 Sri Ujjwal Borua, the son of Dinanath Borua, and PW6 Sri Lakhiram Bora, who is the co-villager of the pro forma defendants. The evidence of DWs also supported the contention of the plaintiff by cordially admitting the fact that suit land belongs to plaintiff Sri Dinanath Borua and defendants have entered into an agreement with him for purchasing the entire suit land. According to PW1, the bainanama was executed in Nagaon sub-registry on Swensoe and rupees 80,000 was paid as an advance on the same day. Thereafter, on 1,399, another 20,000 was paid. So out of total 1,80,000 rupees, 1 lakh have been paid and rupees 82,000 remained unpaid. Defendant 1 and 2 agreed to purchase 12 bighas of land and rest pro forma defendants have agreed to purchase 10 bighas, 3 katha and 15 leches. But regarding this 10 bigha, 3 katha and 15 leches, there is absolutely no dispute. However, out of 96,000, defendants number 1 and 2 paid 55,000 only. The evidence of PW1 further shows that he entrusted the entire exercise such as obtaining sale permission, expenditure involved and other consequential works upon the defendants, and they again entrusted the work to Mukul Hajarika. Accordingly, Sri Mukul Hajarika, defendant number 2, did all preliminary works and took the signature of the plaintiff for that purpose. But on the day of executing the deeds, defendant number 1, Mukul, came late and being asked to pay his remaining amount, Mukul told him to pay the same in the Central Bank Notun Bazar branch. However, due to Saturday, the bank was closed early, so the payment could not be made due to non-payment of money. When the plaintiff refused to execute the deeds, Mukul pressed him for executing the same, promising to pay the balance amount on the next day, Monday, that is on 17/5/99. Accordingly, the plaintiff reached Kampur sub-registry office at 2:30 p.m. In the meantime, deeds were written through the petition writer and kept ready for execution by defendant number 2. Thereafter, believing the defendants in good faith, the plaintiff put his signature on the deeds without verification. Then the deeds were accordingly registered. When the defendant number 2 did not pay the balance amount of 41,000, plaintiff sent his son Ujjwal Borua asking for money. But to his surprise, Mukul refused to pay the remaining amount, stating that the plaintiff executed the gift deed in their favor. As such, there is no question of paying money. By adducing evidence PW3 and 4 and proving the execution of Exhibit 4, Exhibit 5, 6, 7, 8, 9, the plaintiff proved that he entered into an agreement of sale of suit land in his with the defendants. Exhibit 10, which is duly proved by evidence of PW4, the plaintiff proved it in categorical terms that on 30th of January 1999, he executed 4 bainanama with the defendants for selling 22 bighas, 3 katas and 15 leches of land. The evidence of PW5 further consolidated the contention of the plaintiffs. Evidence of PW6, Sri Lakhiram Bora, the pro forma defendant number 6, is more categorical and unequivocal. According to him, along with other defendants, he also purchased land from the plaintiff. However, entire pre-purchase works were done by defendant number 2, and he informed them all about permission and preparedness. Having completed the formalities, they all went to Kampur sub-register office and deeds were executed on the same day. However, the defendant number 2 told the plaintiff that he will pay his share in the bank and took the son of the plaintiff to the bank for payment, but it is not known to him whether the payment was made or not, but deeds were executed. On the other hand, both the DWs categorically deposed in their evidence that they entered into an agreement with the plaintiff for purchasing the suit land, and pursuant to the agreement, part payment was made and thereafter deeds were executed, promising to clear the balance amount within the next week. Therefore, to this extent, it has become crystal clear that the plaintiff is the owner of the suit land and offenders were purchasers. The ownership of the suit land is undisputed one. But the problem arises when the defendant number 1 and 2 claim that deeds number so and so were gift deeds and not sale deeds. According to defendant number 1 and 2, plaintiff is an educated and learned man and he knowingly executed the gift deeds in their favor. So when the plaintiff knowingly executed the gift deeds in favor of defendant number 1 and 2, subsequently he can't deny the execution of the deeds, stating that he did not read the documents and put his signature in his deeds in good faith. Defendant number 1 and 2 also claimed that pursuant to the deeds, plaintiff also delivered possession to them, but the plaintiff denied delivery of possession. During the course of argument, the learned counsel appearing for the plaintiff and profound defendants argued that defendant number 2, taking advantage of honesty and trust of the plaintiff, tactfully executed the deeds number so and so as deeds in their favor, along with other sale deeds executed in favor of other profound defendants. As the defendant number 2 took the lead in the entire process, he conceived the idea of defrauding the plaintiff by preparing the gift deeds in their favor instead of sale deeds as are agreed upon. In the plaintiff specifically pleaded fraud on the part of defendant number 2, and by adducing evidence, plaintiff unfolded the ill design and fraudulent motive of the defendant number 1 and 2. Therefore, the aforesaid deeds were liable to be cancelled as the same were obtained by fraud by misusing trust that has been reposed on the defendant number 2 by the plaintiff. On the other hand, counsel appearing for the defendant number 1 and 2 stated that plaintiff cannot approbate and reprobate at the same time. After executing the gift deeds by his own hand, the plaintiff cannot deny its execution alleging fraud. Plaintiff is assured by his own conduct to deny the execution of gift deeds. In support of their contention, the learned counsel for has referred a decision of the Honorable Apex Court reported in so. In that judgment, it was held that though estoppel is described as a mere use of evidence, it may have the effect of creating substantive rights as against the person estopped. But it was further held in paragraph 27 that of course, an estoppel cannot have the effort of conferring upon a person a legal status expressly denied to him by a statute. But where such is not the case, a right may be claimed as having come into existence on the basis of estoppel, and it is capable of being informed or defended as against the person precluded from denying it. Having gone through the decisions, it transpired that Honorable Apex Court decided the case on an entirely different facts and circumstances of the case. Although the principle enunciated by the Honorable Apex Court is binding on us, but considering the facts and circumstances of the instant case, I find that the principle is not applicable in the case at hand because the evidence of DW3, Golok Chandra Bora, Sri Dinanath Borua clearly shows that he wrote the deeds according to instructions of Mukul Hajarika, defendant number 2. In his cross-examination, he clearly stated that he did not get the opportunity to read over the deeds to Sri Dinanath Borua because Mukul Hajarika, defendant number 2, in the meantime, took the deeds from him immediately. Sri Dinanath Borua put his signature over these deeds. Moreover, his evidence clearly shows that at the time of writing the sale deeds, sale permission of order was not shown to him. This couples with the evidence of PW1 clearly show that defendant number 2 had tacitly obtained the signature of the plaintiff over deeds number so without giving an opportunity to the plaintiff to go through the contents of the deeds. Therefore, I find substance in the evidence of PW1. Moreover, evidence of plaintiff as well as defendant number 2 as DW1 is clearly shows that original bayanama between them was for sale and not for gift. Defendant number 2 in his evidence categorically stated that he neither sought any gift nor accepted it. Plaintiff Dinanath Sharma is also not his near and dear ones to make any gift deed in his favor. He also admitted that he looked after all the transactions on behalf of Srimati Noni Borua also, who is his sister under the circumstances. It goes without saying that defendant number 2 had fraudulently got these deeds executed as gift deeds with a view to defraud the plaintiff under the garb of executing sale deeds along with other sale deeds. Therefore, it appears to me that defendant has failed to show with credible and clearest evidence that the plaintiff has defrauded him by executing a sale deed instead of gift deed. Rather, he has defrauded the plaintiff by tactfully obtaining the gift deeds instead of the sale deed. Given the conduct of defendant number 2 and his evidence shown that equity is in his favor, it is against the common since that a person who executed a bayanama for sale and received consideration money in terms of bayanama and executed gift deeds instead of sale deeds to the detriment of his interest against an stranger. By any stretch of imagination, this proposition is against the normal human conduct. Therefore, as discussed above, I am firm in holding that the plaintiff has right title interest over the suit land, and gift deed numbers so and so are out, fraudulent and liable to be cancelled. The suit is also not based on by any waiver, estoppel, or acquiescence. The possession of such land by defendant number 1 and 2 is also not clearly proved. This is important. When a trial court says the possession of the land by defendant number 1 and 2 is also not clearly proved, because both the DWs, namely DW 1 and 2, stated that possession of the suit land was delivered to them 3 months prior to execution of the deeds, which fact has been categorically denied by PW 1 and 2. The evidence of the defendants carry less credibility in view of the fact that without execution of the sale deeds, delivery of possession is a misnomer. Defendant number 1 and 2 have not re-amended, one and two have to any independent witness to show that possession was delivered in presence of them. Under the circumstances, the entire evidence of defendant number 1 and 2 are found untrustworthy. Therefore, all the 4 issues are decided in favor of the plaintiff and against defendant number 1 and 2. Now, so far as appellate court is concerned, my lord, appellate court has affirmed the judgment passed by the trial court at page 52. 70, Lordship may kindly turn. I'll show there's just specific portion, my name.
70?
Page 70.
70. Yes.
The third paragraph, my lord. It is an admitted position that in order to complete gift as per provision of Transfer of Property Act, acceptance of the gift property is an essential factor along with other essential characteristics such as it must be made voluntarily and without consideration. In this suit, the appellant never denied that they did not pay any consideration amount in favor of the respondent and vendor with regard to the suit property. Since the appellants have claimed that the respondent had executed gift deed being number so and so in respect of the suit land, it was their duty to prove the same, that the respondent vendor had executed the same voluntarily. But the record does not disclose that the vendor had executed the same voluntarily or the gift property was accepted by the donee appellants for the completion of the process of alleged gift. Since the respondents denied to have executed alleged gift, the onus is on the appellants to discharge their burden relating to undue influence. But the appellants have failed to discharge their liability. It may be mentioned here that the appellants have admitted the execution of bayanama by the respondent along with the intending purchasers prior to execution of the deeds. These being so, in the absence of essential characteristic of gift envisaged in TP Act, it cannot be reasonably held that the respondent voluntarily executed the gift deed number so and so in favor of the appellants and the latter have accepted the same. I find force in the submission of the learned counsel for the respondent. Therefore, it can be presumed that the contract for sale of immovable property has been induced by undue influence. Lordship, kindly see this, nobody's case, my lord. Therefore, it can be presumed that the contract for the sale, contract means the initial agreement, my lord, for sale of the immovable property has been induced by undue influence. And this is not the case of the plaintiff, so far as the initial agreement to sell is concerned. And the aforementioned deeds were obtained by the appellants fraudulently from the respondent and the same are liable to be cancelled. Thus, I find that learned trial court has rightly decided the issue in affirmative. Then, so far as possession is concerned, my lord, it has been separately discussed in issue number 6 at page 72, my lord. Next page. issue number 6. The defendant appellants averred in their written statement as well as in their evidence as DW1 that the respondent delivered the possession of the suit land at the time of execution of Bayanama. Whereas PW2 Jalaluddin, who is a cultivator by profession, categorically stated that he has been cultivating the plot of land measuring 12 bighas, 3 kathas, 15 acres of suit land, and the rest plot of land 10 bighas was delivered to its pattadars by the plaintiff respondent. PW1, that is the respondent, also categorically denied the possession of the appellants over the suit land. Even the DW2 Sri Madhav Chandra Bora also specifically stated nothing about the delivery of possession of the suit land in favor of the appellants. Therefore, it transpires that the evidence of the appellants carries less credibility so far their possession over the suit land, and there is nothing on record to enable this court to place reliance on the evidence of the appellants so far as their possession with regard to the suit land is concerned. In view of the above, it is difficult to reasonably hold that the appellants are in possession of the suit land since the date of execution of the Bayanama dated 30th of January 1999. So there is no clear finding as to now there is on the time at the time of delivery of the judgment who is in possession. There is no finding.
No. Earlier you have submitted that the plaintiff admitted in cross-examination
Yeah.
that it was transferred.
Delivered, yes. That I'll show, my lord. That I am yet to show.
Okay.
I'm showing only the finding of the learned two courts below, my lord. Trial court has given a vague finding. First appellate court says that it is difficult to reasonably hold that the appellants are in possession of the suit land since the date of execution of the Bayanama, but trial court or the first appellate court at least was required to record a finding about the possession of the parties on the date of the judgment so as to decide as to whether a decree of recovery of possession having not been paid, the relief can be granted. If there is no finding that today he is in possession of the land, then there is a requirement of recording a finding that he is not entitled to recovery possession because today he doesn't have a possession. Now I'll show from the evidence, my lord, what is there in admission of PW1, my lord. Plaintiff's case is that they have not delivered possession. Defendant's case, pleaded case is very clear that they have got possession because possession was delivered to them. Because in the written statement, my lord, they have taken a clear stand. I'm just showing for a moment. Page 116 of your kindness, it's a part of the written statement. Part of paragraph 24, they have where they have given the real fact. Real fact starts from para 24 at page 115, man. And I am showing, man, from the last paragraph, sub-paragraph of this para 24 at page 116, man. At the bottom, be it mentioned that including the suit land, all total area of land is 12 bigha, 3 kata, 15 acres of land. And the possession of the same was delivered to the defendants at the time of executing the deed of agreement for the sale of the land. This is the stand of the defendant, madam. Plaintiff says they are in possession. Now, from the evidence, what you will find.
No, that was a plea in the written statement.
My lord.
But whether they could establish the same during trial.
That is what I'm showing now, madam, from the evidence. If the plaintiff admits that possession was delivered, then possibly from the defendant side, they have in the evidence also, they have also said that possession was delivered.
Okay.
And plaintiff also admitted. What I am trying to submit before your lordship is, when the plaintiff himself admits, then in terms of Order 5, Rule 8 and Section 58 of the Evidence Act, admitted fact need not be proved. So I'm showing from the cross-examination of PW1, madam. If your lordship kindly takes the cross-examination of PW1.
It is part of this record?
My lord, it is not a part, my lordship will have to kindly. And my lord, we prepared this paper book, and I told it was submitted, or to be lordship can see from. The record is there. From the record only we have prepared.
Okay. Yes, page number.
My lord, internal page, there is Dinonath, if PW1 is Dinonath Borua, my lord.
Hmm.
If your lordship kindly turns to internal page 12. Page 12 possibly is flag mark, my lord.
Hmm.
At the bottom, my lord, the last word Baki,
Hmm.
then page 12. At the bottom, the last word is Baki. Next
Hmm.
page, my lord. Baki Koridar Goneo.
Hmm.
That is profound defense number 3 to 7.
Hmm.
খৰিদাৰ গণেও দান দলিল বুলি পিছতহে জানিব পাৰে। গোচৰীয় জমিৰ দখল দিয়া সময়ত মই যোৱা নাছিলো। মোৰ কামলা জালালউদ্দিনে মোৰ হৈ জমিৰ দখল দিছে। Then, my lord, in this para 13 itself, at the bottom, lordship will kindly see, sixth line from bottom. এই বছৰৰ আগে মই দাবী দণ্ডবিধি হ'ব, my lord, আইনৰ 146 ধাৰা গোচৰ কৰোঁ। সেই গোচৰৰ হুকুম 1-2 নম্বৰ বিবাদীয়ে আপিল কৰাত মাননীয় আদালতে নাকচ কৰে।
জজ আদালতে।
জজ আদালতে নাকচ কৰে। উক্ত গোচৰতো দান দলিল কৰা বুলি জনাৰ পিছত কৰোঁ। 146 ধাৰাৰ গোচৰত মই মাটি বিক্ৰী কৰিব বিচৰাৰ পইচা মানে উল্লেখ কৰা নাই। In the 144 proceeding, there is no mention. Let's see, is in place of sale deed, you have made gift deed, etc. So that was not their objection. Then, my lord, at page 14, this page, at the bottom, lord will find there is one sentence. Baki খৰিদাৰৰ দান দলিল যদিও মই বিক্ৰী মূল্য আদায় পোৱাত আপত্তি কৰা নাই। তেওঁলোকৰ দলিলতো তেওঁলোক মোৰ সহোদৰ ভাই ভনী লিখিছো যদিও তেওঁলোক মোৰ সহোদৰ ভাই ভনী নহয়। My lord, so far as
Mr. Majumdar,
my lord.
so in a gift deed, who has to hand over the possession?
My lord,
The owner of the property?
my lord, no, my lord, so far as the transfer property is concerned and the Hindu law is concerned, my lord, at the time of execution of the gift deed, the question of delivery possession, etc., is not relevant in my humble submission. In the Mohammedan law, delivery possession is necessary. In Hindu law, it is not necessary. Gift deed, if you go specifically in terms of section 122, I think, of the Transfer Property Act, if it is a gift, we are also saying that it was a sale. We have not prepared the gift deed. You have deliberately signed. What happened, why they have executed gift deed. But our case is that you have signed after reading this document, you were a literate person. And you also say that I did not object the same because there is a reason why they did not object. So far as the similar gift deed in respect of the other defendants who were also the purchaser in the original agreement to sell. That means, my lord, give in what circumstances gift deed were executed, but he is not basically averse to or opposed to the execution of a gift deed in place of sale deed. His grievance is that I have not received the balance amount of consideration. It is not a grievance that I did not want to sell and some document was fraudulently executed. Your case is that initially, admittedly, I have executed an agreement to sell. I have received an amount in advance. Subsequently, at the time of execution of the sale deed, instead of sale deed, you have prepared a gift deed. Even then, I have got no objection, provided you pay me the balance amount. But you have not paid the balance amount of consideration. And the agreement of sale, my lord, was common for both the parties. Defendant number 1 to 2 on the one hand, and pro forma defendant number 3 to 7 on the other. By the same agreement. One agreement, my lord. Agreement was one. Transfer documents were different. And not one, more than one in respect of both the parties. So far as defendant number 1 and 2 are concerned, there are 3. So far as defendant number 3 to 7 are concerned, I think there are 4. So, my lord, what I am submitting is, my lord, from these admissions of the PW1, two things are very clear. Possession was delivered to plaintiff. Now, so defendant, defendants are in possession of the land, admittedly. Learned trial court as well as the first circuit court, my lord, while recording a finding with regard to possession of the land, did not take into consideration this specific admission of PW1, who is the plaintiff. And that way, the finding on the issue of possession is clearly perverse. And your lordship, in exercise of your lordship's power under section 100 of the CPC, my lord, will definitely interfere with a perverse finding. So far as the prayer for declaring the gift deeds as void on the ground that they wanted to execute a sale deed, my lord, how does it matter whether it's a sale deed or gift deed? Question is of transfer of title. You are
but legal character of this
technically,
gift deed
my lord,
and sale deed are different.
my lord, technically it is different. That is why, my lord, we are taking the aid of section 55 and 54 of the Transfer of Property Act, which says that you have admittedly accepted the advance amount. You have admittedly till now, you are not opposing or objecting to the agreement to sell. Now, so far as the advance amount is concerned, that amount also you are not saying that I'll return. You cannot be allowed to retain the advance amount of 55,000 if you say that it is not a valid document. And thirdly, what is more important is, my lord, the intention of the parties. Intention of the parties are very, very clear that plaintiff wanted to sell, defendant wanted to purchase. Only thing is, the document of transfer was a gift in place of a sale deed. And my submission before your lordship, my lord, which I am possibly making repeatedly, that when the intention of both the parties, particularly the plaintiff, is very clear that he wanted to sell, he is not saying anywhere, or it is not his case, that I did not want to sell the land and you have fraudulently created or manufactured a document of sale or transfer, which I am challenging. That would have been a completely different case altogether, my lord. Here is a case where your intention is to sell. Now, by making an admission in your cross-examination, that see, in respect of pro forma defendant number 3 to 7 also, there are gift deeds. But I am not objecting because this is very clear. I have not objected to those gift deeds because I received the full consideration amount. Now, on the ground that he did not receive the full consideration amount, whether the gift deeds can be declared void, more so when receipt of advance amount is admitted, possession is with the defendant is admitted, agreement to sell is not challenged even till today. intention of the parties, particularly the plaintiff, to sell the land is very, very clear. They have nowhere said that we never intended to transfer the land. It is rather the reverse which is correct. That I want to sell, I wanted to transfer, but I did not receive the balance amount of consideration. So, my lord, in view of these findings, my submission before your lordship is till the judgment of Akamma, my lord, I would have argued because of the nature of prayer that recovery of possession as a consequential relief was not asked for. I would have argued that the suit is not maintainable, but because of the judgment of Akamma, my lord, I will say the relief of recovery of possession cannot be granted because there is no consequential prayer. This is what the Supreme Court said. I'll read the judgment, my lord. I'm just making my submission. That is my first submission, my lord. And secondly, my lord, when the intention of the parties is very clear and considering the admission of the plaintiff in the cross-examination, and my lord, with regard to possession, my lord, one more part I have to show, my lord, from the evidence of PW2. PW1, who is the plaintiff, he said that I did not hand over possession. My Kamla, Jalaluddin, handed over possession on my behalf. Now, Jalaluddin was also examined by the plaintiff. And Jalaluddin also, in his evidence, said, my lord, which your lordship will find in PW2's, my lord, deposition. Second page, my lord. Line about 8 or 9 from bottom. Bikri kora jomir, lordship has got, my lord. Ninth line from the bottom.
Page number?
Page, second page, internal page of PW2, my lord.
Okay.
It
Yes,
is in this
Bikri kora-
my lord, second paragraph.
Got it.
Yes.
Hmm.
Bikri kora jomir dohol. Page. বাদীৰ হুকুম মতে মই সমঝাই দিওঁ বাকি থকা 12 বিঘা পুনলেচা জমিত মই এতিয়াও খেতি কৰি আছো. This is slightly against us. Then cross starts from page 3, my lord. Then internal page 6, lordship will find. From top, my lord, third line from top. Right hand side, জমি বিক্ৰী কৰাৰ পিছত শাওণ মাহত মই দখল সমঝাই দিওঁ দীননাথ তেতিয়া উপস্থিত নাছিল মুকুলে মাটি দখল কৰিবলৈ কেতিয়াও যোৱা নাছিল. Now next page, para 7 is also important, my lord. Line about 6th from top, 7th, my lord. বিক্ৰী দলিল কৰাৰ ছমাহমান পাছত বাদীয়ে মোক দখল সমঝাই দিব কৈছিল. বাদীয়ে কোৱাৰ 4-5 দিন পাছত মই দখল সমঝাই দিওঁ লক্ষীৰামহঁতক. So this is the position, madam. Yes. Yeah. ও আকামাতে বলছি একটু পারবে এটাতে বলছি পারবে পারবে না.
Oh, who is Lokhiram?
And then PW, evidence of PW6 also is important, my lord. Lokhiram Bora,
Okay.
PW6, ma'am. PW6, my lord, will possibly marking is there. Internal page 4, huh? Internal page 4 is important, my lord. Possibly it's marked. Running page 42, I think. Internal page 4 of Lakhiram Bora, PW6.
Hmm.
Internal page 4 of PW6.
Yes.
Well, from top, and fifth line from top, Mukule. মুকুলে কিনা মাটি খিনি মুকুল হতেও হাল বোৱা দেখিছো আৰু দীননাথেও হাল বোৱা দেখিছো।
So, Mr. Mazumdar,
My lord,
upon this kind of evidence, whether a definite finding could be arrived at by the learned courts below in respect of the possession?
that is what, my lord, that is the question. Now, if it is, I'm not plaintiff, my lord, it is a plaintiff case. Plaintiff will succeed or fall on the case he establishes. This is what the Honorable Supreme Court has said. Now, he has to clearly show that he is in possession and defendants are not in possession. Now, his witness says that Mukule halboa dekhisu. Mukule means appellant and defendant. So it is for it burden is on the plaintiff to show that they are in possession, so as to be entitled to the relief of confirmation of possession. Now, if he fails to show that clearly that he is in possession and defendants never cultivated, how can the court will grant a decrement? It is for the plaintiff to show. We are for the defendant, my lord.
But there is concurrent finding of fact by the courts below.
On possession, my lord, but those findings are perverse, clearly, my lord. These evidences, it is another thing that's what finding has been recorded. These evidence has not been discussed. Admission of the PW1, Jalaluddin, then PW6, Mukule halboa dekhichilu. My lord, what will happen to a land when the plaintiff claims I am in possession, but plaintiff himself says possession was delivered, Jalaluddin says possession was delivered, and PW6 is much more clear, who says that Mukule halboa dekhisu.
No, it's the second line, dinonatheo halboa dekhisu.
Yes. So it is, that's what I'm saying, my lord. In these circumstances, it will be, the court will have to take a call what kind of finding is to be recorded. Plaintiff has to show clearly that he is exclusively in possession. Otherwise, there will be a question of recovery of possession. If Mukul is cultivating, then that means Mukul is in possession. Well, cultivation is an activity which, unless a person is in possession, cultivation doesn't take place in 1 minute or 2 minutes. Your lordship is aware, I am not that much aware, your lordship may be aware, that for cultivation, my lord, a whole exercise is necessary. People will go in the morning and for days together, they will be plowing.
Maybe nowadays in the evening also they can plow.
Machine is also there.
Machine is there.
And it's in
Anyway.
99. Anyway, what I'm saying is, so far as the finding recorded on the issue of possession is concerned, these relevant materials, relevant evidence was not at all discussed.
You see, this matter is of 2009.
My lord.
Title suit of 99. Purchase
Any other point?
Yes, man, I'm showing the judgments, I'll just point out.
Yes.
না, it should be class A. আচ্ছা, প্রথমে আমার নোটগুলো দেখি। 99 please. Well, first I'll read a particular paragraph from 1999, volume 3 SCC, page 573. This is on 54B of the transfer of property. And this 99(3) SSC, page 573, I am relying on paragraph 36 to 43, my lord.
5-7.
573,
Okay. Paragraph number.
paragraph 36 to 43, my lord. Lordship may kindly take note, my lord.
Yes.
36 to 43, my lord.
Hmm.
36 I am reading, my lord.
Hmm.
The definition indicates that in order to constitute a sale, there must be a transfer of ownership from one person to another. That is, transfer of all rights and interests in the properties which are possessed by that person are transferred by him to another person. Transferor cannot retain any part of his interest or right in that property or sale. It would not be a, or else it would not be a sale. The definition further says that the transfer of ownership has to be for a price paid or promised, or part paid and part promised. Price thus constitutes an essential ingredient of the transaction of sale. The words price paid or promised or part promised indicate that actual payment of the whole of the price at the time of execution of sale deed is not a sine qua non to the completion of the sale. As in our case, my lord, at the time of execution of the sale, whole price, at least according to the plaintiff, was not paid. Even if the whole of the price is not paid, but the document is executed and thereafter registered, if the property is of the value of more than ₹100, the sale would be complete. There is a catena of decisions of the various high courts in which it has been held that even if the whole of the price is not paid, the transaction of sale will take effect and the title would pass under that transaction. To cite only a few, in Gayatri Prasad versus so it was held that non-payment of a portion of the sale price would not affect validity of sale. It was observed that part payment of consideration by the vendee itself proved the intention to pay the remaining amount of sale price. To the same effect is the decision of the MP High Court in so. The real test is the intention of the parties. In order to constitute a sale, the parties must intend to transfer the ownership of the property, and they must also intend that the price would be paid either in presently or in future. The intention is to be gathered from the recital in the sale deed, the conduct of the parties, and the evidence on record. Then, my lord, para 40, the provisions of section 55 have been quoted, and then para 41, Lord, should you kindly see. Clause B extracted above provides that where the ownership of the property is transferred to the buyer before payment of the whole of the sale price, vendor is entitled to a charge on that property for the amount of the sale price as also for interest thereon from the date of delivery of possession. Originally, there was no provision with regard to the date from which interest would be payable on the amount unpaid purchase money. The special committee which suggested an amendment in the sales section gave the following reasoning. But this is, we're not very much concerned. Para 42 is important, my lord. The clause obviously applies to a situation where the ownership in the property has passed to the buyer before the whole of the purchase money was paid to the seller or the vendor. What is contained in this clause is based on the English doctrine of equitable lien as propounded by Baron Rolfe in so-and-so versus so-and-so. This clause confers statutory recognition on the English doctrine of equitable lien. As pointed out by the Privy Council in so-and-so, the statutory charge under this paragraph is inflexible. The charge does not entitle the seller to retain possession of the property as against the buyer, but it positively gives him a right to enforce the charge by suit. Then para 43, my lord. In view of the above, High Court was wholly in error in coming to the conclusion that there was a sale as only a sum of which 500 was paid to the defendant number 2 and the balance amount of which 4,500 was not paid. Since the title in the property had already passed, even if the balance amount of sale price was not paid, the sale would not become invalid. The property sold would stand transferred to the buyer subject to the statutory charge for the unpaid part of the sale price. Now, para 48, Lord, shall kindly see for a moment, just one more paragraph, my lord, para 48. The basic principle is that the form of transaction is not the final test. And the true test is the intention of the parties in entering into transaction. If the intention of the parties was that the transfer was by security, it would be a mortgage. The Privy Council, as early as in so-and-so, has laid down that as between the parties to the document, the intention to treat the transaction as an out and out sale or as a mortgage has to be found out on a consideration of the contents of the documents in the light of surrounding circumstances. Well, on the basis of this judgment, well, what I'm contending is that, well, although the document was ultimately a gift deed, in view of the fact that plaintiff himself says that I am not very much on the nature of the document, because similar nature of document in respect of different number 3 to 7, I have not raised any objection for the simple reason that I have received the full consideration amount. That being the so, my lord, when the intention of the plaintiff is to sell the property, your lordship will consider whether in such a situation, whether in view of this judgment, my lord, the plaintiff will have only a charge for enforcing his right to recover the balance amount, or the document itself can be set aside, because if the document is set aside, many things will come in, like whether the defendant will have to again file a suit for specific performance of contract because original agreement is there. The agreement is still valid. Secondly, the plaintiff is still retaining that advance amount of 55,000. It is not his case that I want to return, because his case is that I want the balance amount of money. And well, so far as that maintainability of the suit on the ground that there is no prayer for recovery of possession is concerned, my lord, I am relying on the judgment of 2021 18 SSC, page 371. Para 21. I am actually relying on paragraphs 21 to 26, my lord. 21 to 26. इसलिए हो जाए।
Yes.
We agree, 21, madam. We agree with that part of the decision of the High Court in which it has been held that a possession of the suit property was not established by the plaintiff, and hence injunction relief could not be granted. As we have already reported, we are also in agreement with the High Court's reasoning for rejecting the plea for amendment, but we do not agree fully with the entire reasoning of the High Court for dismissal of the appeal as spelled out in the said judgment. The bar contained in proviso to section 34 of the 1963 Act, in our opinion, could not be applied in the case of the plaintiff, as consequential relief for injunction from interference with the suit land was claimed. The prohibition contained in the proviso to section 34 would operate only if the sole relief is for declaration without any consequential relief. Then para 22, Lordship will see, the prohibition or bar contained in the proviso to section 34 of the Act determines the maintainability of the suit, and that issue has to be tested on the basis of the plaint is framed. If the plaint contains claims for declaratory relief, as also consequential relief in the form of injunction, that would insulate the suit from any attack of maintainability on the sole ground of bar mandated in the proviso to the aforesaid section. If on the evidence the plaintiff fails on the consequential relief, the suit may be dismissed on merit so far as the plea for consequential relief is concerned, but not on maintainability question invoking the proviso to section 34 of the 1963 Act. If the plaintiff otherwise succeeds in getting the declared relief, such relief could be granted. On this count, we do not accept the ratio in Karnataka High Court judgment in so and so. Then, my lord, para 26, that portion where I earlier made a submission. Para 26, my lord. From the bottom, maybe from 10, 11 line, on the right hand side, maybe such a declaratory. Not sure, my lord. Maybe such a declaratory, right? Declaratory decree would be non-executable in the facts of this case, but for that reason alone, such a declaration cannot be denied to the plaintiff. So declaration of title can be granted, but recovery of possession cannot be granted. Earlier, the judgment on the Supreme Court said earlier that suit itself will be not maintainable. But now the Supreme Court has modified in this case, saying that if there is a prayer for consequential relief of injunction, then the whole suit cannot be said to be not maintainable. But yes, so far as the declaration is concerned, that can be granted. But so far as his prayer of consequential relief of recovery of possession is concerned, that cannot be granted. And then it says, maybe such declaratory decree would be non-executable in the facts of this case. Because if there is no decree for recovery of possession, it will not be an executable decree. This is what the Supreme Court has clarified. কি করবে আমরা এটা অন্য পড়লাম আল্লাহ মানে কি দেখো আপনার So in view of these, my lord, and the judgments on which I have placed reliance, recent
Yes, any other point?
Well, one point I would like to place before your lordship, my lord, that if the plaintiff insists that he is entitled to, in view of what I have submitted, my lord, my submission will be that plaintiff is not entitled to the decree of declaring those gift deeds as void. And if he still insists that instead of passing a decree of recovery of the balance amount, then, my lord, his suit itself will not be maintainable. And if his suit is not maintainable, even at this stage, my lord, lordship can hold that the suit is not maintainable. For that, my lord, I am relying on one judgment, a very recent judgment, my lord. 2025 3 SCC. Listen. 2025 3 SCC, page 513.
Relevant paragraph?
My lord, relevant paragraphs are paragraph 40 to 44, my lord.
Yes.
My lord, these paragraphs I am relying on, let me make it clear, my lord. This judgment and also these paragraphs I am relying for the purpose of showing that even if no plea on this question, my lord, was raised before the learned courts below, it can always be raised even before your lordship. para 40 says, my lord, having held thus, allowing the appeal is the inevitable result. However, before we part, there seems to be a discordant note struck by the decision in so-and-so while discussing so-and-so, which would create uncertainty and confusion. It is therefore considered worthwhile to attempt and clear the same. A comprehensive reading of the two decisions reveals that in a fact scenario where the vendor unilaterally cancels an agreement for sale, the vendee who is seeking specific performance of such agreement ought to seek declaratory decree to effect that the cancellation is bad and not binding on the vendee. This is because an agreement which has been cancelled would be rendered non-existent in the eye of law, and such a non-existent agreement could not possibly be enforced before a court of law, but the decisions cited above are unanimous in their approval of such legal principle. However, as clarified in Kanthamai, it is imperative that an issue be framed with respect to maintainability of the suit on such ground before the court of first instance, as it is only when a finding on the issue of maintainability is rendered by the trial court that the same can be examined by the first or and second appellate court. In other words, if the maintainability were not an issue before the trial court or the appellate court, a suit cannot be dismissed as not maintainable. This is what Kanthamai holds. The aforesaid two decisions of this court expressed by the court in benches demand deference. However, it is noticed that this court in Kanthamai had not addressed on the effect of non-existence of a jurisdictional fact. That is, what would be its effect on the right to relief claimed by the plaintiff in a suit for specific performance of contract. Then, my lord, then I can straightway go to paragraph 45, my lord. Should the trial court not satisfy itself that a jurisdictional fact for grant of relief does exist, nothing prevents the court higher in hierarchy from so satisfying itself. It is true that the point of maintainability of a suit has to be looked only through the prism of section 9 CPC, and the court can rule on such point either upon framing of an issue or even prior thereto, if Order 7, Rule 11D thereof is applicable. In a fit and proper case, notwithstanding omission of the trial court to frame an issue touching jurisdictional fact, High Court would be justified in pronouncing its verdict upon application of the test laid down in Srishti Dhawan. Then para 47, my lord. However, we clarify that any failure or omission on the part of the trial court to frame an issue on maintainability of a suit touching jurisdictional fact by itself cannot trim the powers of the higher court to examine whether the jurisdictional fact did exist for grant of relief as claimed, provided no new facts were required to be pleaded and no new evidence led. My lord, what has happened in this case, my lord? There was an agreement to sell, and then there was a suit for specific performance of contract. Now, the discussion of the Honorable Supreme Court is this, that if before the suit for specific performance of contract is filed, the agreement to sell is cancelled, then in the suit, apart from the prayer for specific performance of the contract, the plaintiff also has to pray for a declaration that the cancellation of the agreement to sell is void. Without praying for that, my lord, the suit will be bad. Now, in that connection, in that context, my lord, the question came up that this issue which is being argued was not pressed before the learned trial court, nor it was raised or decided by the first appellate court. Then the Honorable Supreme Court says, if the jurisdictional facts are absent, the higher court can always examine the matter and the question of maintainability can always be decided. It is on this, my lord, premise that I am relying on the judgment to show that if in the facts of this case, it is apparent that the plaintiff had the intention to transfer, but in place of a sale deed, a gift deed was executed, but the agreement to sell is there, the prayer for refund of the advance amount to the defendant is not there, agreement to sell is to be, it can be avoided, is not there, possession is with the defendant. In that view of the matter, my lord, the suit as framed for declaring the gift deed as void, in my humble submission, would not be maintainable. And for that, my lord, I am relying on the judgment. That's all.
Mr. Poirot, we'll resume at 2 o'clock. Is
Yes, I could not file the IA lordship for stay of the execution proceeding because my first of morning lordship.
No, you
first
can
out-
file later on also. The
Lordship-
question is whether there is substantial question of law or not. That has to be determined
Lordship.
first.
Lordship. But if required, we'll amend the substantial questions of law if a law for satisfaction of the lordship. Fix a date, then I'll be.
You have already argued the matter.
No, regarding stay of execution,
Sorry.
IA lordship,
You can file later on, provided we admit the appeal.
lordship.
Yes.
May please, your lordship.
Hmm.
I'll take your lordship directly to the plaintiff page 18. Page 88, but of different internal page 9.
Yes.
Because I'll show your lordship that I have specifically pleaded fraud that your lordship will find about 7-8 lines from the bottom of page 88.
Hmm.
He came to know that the deeds were prepared fraudulently, collusively by defendant number 1 and 2 as deeds of gift in place of. Sorry, just a minute. Just a minute. Just a minute. Yes. Then your lordship will see
In page number, internal page number 9
9.
from,
He came to know that the deeds were prepared fraudulently, collusively by defendant number 1 and 2 as deed of gifts in place of excellence.
from
After
where you
calling-
were reading?
Page 88 from bottom around 1, 2, 3, 4, 5, 6, 7, 8 line. He came to know. 8 line. Internal page 9.
Yes.
Then 9 lines from the bottom. Madam. He came to know. Your lordship got it? He
Yes, got it.
The beginning line said that they said that they would pay on Monday at his house at Nagaon.
From the bottom, it's the 8th line.
It would. About 18 to 20.
Came to know.
It played of the titles.
Version 9 that also. Is it? Is it? Wait, no.
Apply look the web page to page 18.
Okay, yes.
Note then. After collecting the data, he came to know that there had been mentioned the defendant number 1 and 2 was consequent brothers of the plaintiff and they have been maintaining with love and affection the plaintiff. Then your lordship will omit this and next go to paragraph number 7 at the next page.
Yes.
Paragraph number 7, then as per the statement made about that the defendant number 1 has prepared the gift test fraudulently and illegally.
Hmm.
No, yes. There as per the statement made about the defendant number 1 had prepared the gift test fraudulently and illegally in their names without knowledge of the plaintiff and get it registered the plaintiff no it on 1/6/1999 first. Then your lordship will skip those lines and go to the next page at page 11, internal page.
Hmm.
Page 90. Since the defendant number 1 and 2 have not paid the outstanding amount, just 4 lines, 4 lines. Since the defendant number 1 and 2 have not paid the outstanding amount of rupees 41,000 in respect of the sole land, the plaintiff did not deliver the possession of the sole land to them.
Hmm.
Then another pleading your lordship will look at page 91, that in our internal page 12. This said gifts are baseless, fake and collusive, created by defendant number 1 and 2 collusively.
Yes.
Then your lordship will say the relief sought for at page 93, internal page 40. Because I have already seen it.
Yes.
Your lordship has already seen go. Now your lordship will see go. Any other and further relief as the court may deem fit and proper in the circumstances of the case be awarded in favor of the plaintiff. Now your lordship will now kindly look into the written statement at page 110.
Yes.
Now your lordship will first note their statement as paragraph number 15, 112.
Yes.
Paragraph number 50. That the statement of the plaintiff made in paragraph 4 of the plaint is totally false, fabricated, and concealment of truth. After receiving the entire dues from the defendant, the plaintiff executed the deeds. The answering defendants have nothing to pay the plaintiff after execution of the deed. The possession of the suit land has remained to defendant as in before.
Hmm.
Now your loss will see internal page 430. Internal page 4 of the written statement, page 130, the third line, madam.
Yes.
113. The defendant number 1 was not present at the time of execution of the deed. After receiving entire consideration of sale value, why the plaintiff and his son collusively executed that the gift in spite of sale, they would not be able to say the reason of the sale. Now your another factor also your loss will see here, page 140, internal page 5.
Yes.
Their story, madam, your loss will kindly see 1, 2, 3, 4. Now, their story, your lordship will say, taking sons of simplicity of plaintiff, they got registered and not paid outstanding of rupees. All those are false and consent, they say. Then your lordship will see paragraph number 18, the first, second, third, fourth, fifth line. The suit land has been under possession of the defendant since before and still now it has been under their possession. The possession of land was delivered before registration of deeds and therefore delivery of possession does not arise now. I take your lordship that it was not possible, madam. And their facts, they have stated in paragraph number 24. That your lordship has already read it. Their facts of the real fact of the suit, in their written statement, they have mentioned at paragraph number 24. But interestingly, my lord, this was not read to your lordship. Your lordship will see page 170. Internal page 8. Be it mentioned, the defendants came to know after filing the suit that the plaintiff executed deeds in place of sale. In this regard, the defendant would file separate suit against the plaintiff for filing the counterclaim. This was never filed. I will not burden your lordship to, by going through the first court judgment, because that has already been read over by learned friend. The second appellate court judgment also your lordship has said. Both are of concurrent findings are there. So now in the second appeal, your lordship knows to what extent it can be interpreted. I will take your lordship to that. But your lordship will kindly see the evidence which was read over to you, especially PW2 first. Jalaluddin. I'll only read two of the deposition your lordship will see because Jalaluddin.
Yes.
Your lordship got it. I'll read it from the beginning only. মই বাদী বিবাদী উভয়কে চিনো বাদীক যোৱা 20 বছৰ আগৰ পৰা চিনো তেওঁ চাহ বাগানত চাকৰি কৰিছিল মোৰ ঘৰৰ পৰা উক্ত বাগান প্ৰায় 2.5 মাইল দূৰত উমিলা জননী গাঁৱত থকা বাদীৰ জমিত মই খেতি কৰিছিলো তাত বাদীৰ 22 বিঘা 3 কঠা 15 লেচা মাটি আছে এই মাটি উমিলা জননী আৰু চিতলমাৰী কিসামতত গৰুপাত মৌজাৰ অন্তৰ্গত এই মাটিখিনি এটা চৌহদত অৱস্থিত এই 22 বিঘা 3 কঠা 15 লেচা জমি উত্তৰে চৰকাৰী ৰাস্তাত দক্ষিণে হেলি ৰফিক আৰু পশ্চিমে চালাম পূৰ্বে ৰফিকৰ লগত অনিলো আছে মই উক্ত জমি বাদীৰ পৰা 20 বছৰ আগে মাহে 1000 টকা দৰমহা বন্দবস্ত খেতি কৰো আৰু পাছত বিঘাই 3 মোন ধান দিয়া চুক্তি বন্দবস্ত খেতি কৰো চুক্তি বন্দবস্ত খেতি কৰা 12-13 বছৰ হ'ল গুচৰীয়া মাটিত খেলি ঘৰ 3টা আছে এই ঘৰত মই থাকো এটা ঘৰ পাকঘৰ আৰু আনটো গোহালিতে ইয়াৰে বাদে অন্য কাৰো ঘৰ নাই এই ঘৰ মহিলা জাৰণী কিসামতৰ মাটিতে আছে মই জমিত শালি ধানৰ খেতি হয় দৌ বাম মাটি এই মাটিৰ পৰা প্ৰায় 10 বিঘা মাটি বাদীয়ে বিক্ৰী কৰে বাদীয়ে লক্ষীৰাম হৰেণ বিলেন দুলাল আৰু জীৱনক বিক্ৰী কৰে প্ৰায় 2 বছৰ আগতে বাদী প্ৰায় লক্ষীৰাম হতৰ পৰা মাটি বিক্ৰী কৰাৰ কথা জানো বিক্ৰী কৰা জমিৰ দখল বাদীৰ হুকুম মতে মই সমজাই দিওঁ বাকি থকা 12 বিঘা 3 ঘৰ দিস ইজ দ্য ল্যান্ড অফ দি সুট ল্যান্ড দিস বিক্ৰী কৰা জমিৰ দখল বাদীৰ হুকুম মতে মই সমজাই দিওঁ ইটস টু দ্য প্ৰফৰ্মা ডিফেন্ডেন্ট বাকি থকা 12 বিঘা দিস দ্য সুট ল্যান্ড 3 কঠা 15 লেচা জমিত মই এতিয়াও খেতি কৰি আছো যোৱা বছৰ খেতি কৰি সৰু পানী নষ্ট কৰে 10 মোন ধান বাদ দি দিওঁ তাৰ আগৰ বছৰে মই খেতি কৰো ননী বৰুৱা মুকুল হাজৰিকাক চিনো দিস ইজ ডিপেন্ডেন্ট মুকুলৰ ঘৰ বিবাদী জমিদাৰৰ পৰা 2.5 মাইল দূৰত তেওঁ নগাঁও পানীগাঁৱত থাকে মুকুলে মাটিৰ দখল বিচাৰি গৈছিল মালিকে নোকোৱা বাবে দখল এৰি দিলো বুলি কোৱাত মুকুলে ঘূৰি আহে সেই মাটিত পুলিত যোৱা নাই এই গোচৰৰ বাদে আন গোচৰ হৈছে যদিও মই নাজানো উক্ত জমিত বাৰিষা পানী হয় তাত বাৰী নাই বাৰিষা পানী হলে আমি ৰাস্তাত আহিব লাগে লক্ষীৰাম হৰেণ বিশাল জীৱন মাটি বিক্ৰী কৰা সময়ত মই কামপুৰ সাব ৰেজিষ্ট্ৰাৰ অফিচত আহিছিলো সিদিনা অৰ্থাৎ দলিল কৰা দিনা মুকুলো নদীক মাটি সমজাই দিবলৈ বাদীয়ে মোক কোৱা নাছিল এইবাৰ খেতি ময়ে কৰো বাদীয়ে কলে মই উক্ত জমিৰ পৰা উঠি যাম মোক এতিয়ালৈ বাদীয়ে উঠি যাব কোৱা নাই দেন দ্য ক্ৰছ এই মাটিৰ মাজেদি এটা জান আছে তাত খৰালি পানী নাথাকে মোৰ ঘৰৰ পৰা সেই জানটোলৈ প্ৰায় 10 নল মান দূৰ হিমা ৰফিক সালাম হেলিম আদি বৰ্তমান জীৱিত তেওঁলোক দখল কৰি থকা মাটি ম্যাদী নে চৰকাৰী মই নাজানো মোৰ লগত বন্দবস্তি লিখা পঢ়া হোৱা নাছিল বাগানত মই আগতেই নলাখানা কাম কৰোঁতে তেতিয়া বন্দবস্ত হৈছিল তেতিয়া মোৰ লগত জয়নলা আছিল দৰমহা মই মাহে বাদীৰ পৰা আনো আৰু খেতিৰ শস্য সম্পূৰ্ণ বাদীয়ে লয় এই বছৰ মই 10 মোন ধান আঘোণ মাহত বাদীক দিওঁ 10-15 তাৰিখে মানে দিওঁ মই 30 মোন ধান পাইছিলো এই বছৰ বাদীয়ে এতিয়া টাউনত থাকে আৰু মাজে মাজে মাতিলে যায় 10 মোন ধানটো মই বজাৰত বিক্ৰী কৰি 1500 টকা মই বাদীক ঘৰত দি যাওঁ এই গোচৰটো দিননাথে কাৰ বিৰুদ্ধে কিয় দিয়ে মই নাজানো আমিলাজনীৰ 2 বিঘা 3 কঠা মাটি আছে এই 2 বিঘা 3 কঠা উত্তৰ ফালে ভাল ৰাস্তাত দক্ষিণে বাদী পূবে হৰেণ আৰু পশ্চিমে চালাম চিতলমাৰীত 9 বিঘা 2 কঠা জমি এই 9 বিঘা 2 কঠা উত্তৰে চৰকাৰী জান দক্ষিণে অন্য এটা জান পূবে ৰফিক আৰু পশ্চিমে চালাম মোৰ ঘৰ পমিলা জাৰণী মাটিত ওচৰতে অৰ্থাৎ 4 নল মান আঁতৰত চালামৰ ঘৰ এই মাটিত দাগ 4টা কিন্তু নম্বৰ নাজানো পট্টা নম্বৰো নাজানো মই খেতি কৰা আগতে উক্ত মাটিত খেতি মাটি আছিল আৰু বাবতে আলিয়ে খেতি কৰিছিল আবেদ আলী বৰ্তমান জীৱিত দলিল কৰা দিনা লক্ষীৰামে মোক কোৱাত মই পিছত আহোঁ মুকুল ননী বৰুৱা হৰেণ উজ্জ্বল আদি সকলো দলিল কৰা দিনা ৰেজিষ্ট্ৰাৰ অফিচত উপস্থিত আছিল মোক কেইখন দলিল হয় নাজানো মুকুল আৰু ননীক কিমান মাটি বিক্ৰী কৰে মই নাজানো লক্ষীৰামক 3 বিঘা, হৰেণক 2 বিঘা, বীৰেণক 2 বিঘা, দুলল আৰু জীৱনক 2 বিঘা মাটি বিক্ৰী কৰে। জমি বিক্ৰী কৰাৰ পিছত শাওণ মাহত মই দখল চমজি দিওঁ। দীননাথ তেতিয়া উপস্থিত নাছিল। মুকুলে মাটি দখল কৰিবলৈ কেতিয়াও যোৱা নাছিল। মুকুলৰ ভাই ককাই 4জন। প্ৰমীলা জাননীত ৰাস্তাৰ কাষত তেওঁলোকে থকা ঘৰ আছে। মই খেতিয়ে কৰো, গৰু ব্যৱসায় নকৰো। বিক্ৰী বন্দবস্ত হোৱাৰ সময়ত বাদীয়ে মোক কৈছিল, বন্দবস্ত ক'ত হয় মই নাজানো, মাটি গোটেইখিনি বিক্ৰী বন্দবস্ত হোৱা বুলি মোক কৈছিল। বিঘাই প্ৰতি 8,000 টকা দামত বন্দবস্ত হৈছিল। কাৰ কাৰ লগত বন্দবস্ত হৈছিল মই সোধা নাই আৰু বাদীয়ে মোক কোৱাও নাছিল। দলিল কৰাৰ ডেৰ বছৰ মান আগে বাদীয়ে কৈছিল বিক্ৰী বন্দবস্তৰ কথা। দুটা ঘৰ মই বনাই লওঁ প্ৰায় 8-10 বছৰ আগে। এটা ঘৰ আগৰ পৰা আছিল, তাত মোৰ আগে কাবেদালি আছিল, সেই ঘৰ এতিয়াও আছে। মুকুলহঁতৰ বাদে বাকী কেইজনে সেই মাটিত খেতি কৰি দখল কৰি আছে। মুকুলহঁতৰ বাদে বিক্ৰী দলিল কৰা দুমাহমান পাছত বাদীয়ে মোক দখল চমজাই দিবলৈ কৈছিল। বাদীয়ে কোৱা 4-5 দিনৰ পাছত মই দখল চমজাই দিওঁ লক্ষীৰামক, নট টু মুকুল। লক্ষীৰাম ইজ দ্য প্ৰফৰ্মা ডিফেণ্ডেণ্ট। মোক কোনো দলিল পত্ৰ দেখুওৱা নাছিল। মোৰ ঘৰৰ পূৰ্ব দিশে হৰেণক এইটো সত্য নহয় যে মই প্ৰথম মাহে 1,000 টকা দৰমহাত আৰু পাছত বিঘাই প্ৰতি 3 মোন ধানৰ চুক্তিত খেতি কৰাৰ কথা মিছা। দলিল কৰাৰ সময়ত সাব ৰেজিষ্ট্ৰাৰ অফিচত নথকা কথা সত্য নহয়। এইটো সত্য নহয় যে মই মাটিৰ কথা মতে দখল চমজাই দিয়া কথা মিছা। এইটো সত্য নহয় যে মই উক্ত জমিত 2টা ঘৰ হতা কথা আৰু এটা ঘৰ আগৰ পৰা কথা মিছা। এইটো সত্য নহয় যে মুকুল হাজৰিকাৰ প্ৰপক্ষে খৰিদাৰগণে মাটি বিক্ৰী বন্দবস্ত হোৱাৰ সময়ত জমিৰ দখল চমজি লৈছিল। এইটো সত্য নহয় যে মুকুল হাজৰিকাই জমিৰ দখল লৈ তাক ঘৰ আজি বসবাস কৰিছে আৰু প্ৰায় 4 বিঘা মানে জমিত তামোল গছ আদি লগাই বাৰী পাতিছে আৰু 8 বিঘা জমিত খেতি কৰে। জুমন বিয়াক মই নিচিনো। এইটো সত্য নহয় যে চৰকাৰী জানৰ এই কোণত মই ঘৰ সাজি বসবাস কৰি আছো। এইটো সত্য নহয় যে মই যোৱা বছৰে খেতি কৰা 10 মোন ধান বিক্ৰী কৰে মূল্য আদায় দিয়া কথা মিছা। পুলিচে মাটি জব্দ কৰিবলৈ নাছিল। দলিল কৰিব যোৱা সময়ত বাদীয়ে কোনো আপত্তি কৰা নাছিল। মণ্ডল দি মাটি চমজি দিব বুলি বাদীয়ে মোক কৈছিল। পাছত মণ্ডল লৈ বাদী যোৱা নাছিল। এইটো সত্য নহয় যে বিক্ৰী বন্দবস্ত কৰাৰ সময়ত দখল দিয়া কথা জানি মই বাদীৰ ওচৰত মিছা সাক্ষ্য দিছো আৰু মোৰ দখল কৰাৰ কথা মিছা। The caretaker has categorically said that at no point of time possession was granted to the defendants. Now your lordship will see the PW 6 which was read over to my friend. PW, yes, sir. That's a short one, my lord. I'll read only one more, then I'll not bother you. Lordship got PW 6.
Yes.
দীননাথ বৰুৱা আৰু ননী বৰুৱাকো চিনি পাওঁ। মোকাবিলা বিবাদী 3, 4, 5, 7, 8 আৰু 9 আমি আটাইবোৰে একেখন গাঁৱৰে মানুহ। 3 নম্বৰ বিবাদী হৰেন্দ্ৰ বড়ো মোৰ ভতিজা হয়। বাদী নগাঁও জিলা চিনামণি আৰু প্ৰমীলা কিচামতৰ 22 বিঘা 3 কথা 18 লাখ মাটি আছিল। এই মাটিখিনি বাদীয়ে বেচা বিক্ৰী কৰিবৰ কাৰণে কথাও পাতিছিল আৰু মই আৰু মোৰ ভতিজা হৰেন্দ্ৰই প্ৰত্যেকে 3 বিঘাকৈ কিনিম বুলি কথা পাতো। 1999 চনত বহাগৰ শেষৰ ফালে মাটি কিনাৰ বন্দবস্ত হৈছিল আৰু এখন বয়নাপত্ৰ হৈছিল। 2 নম্বৰ বিবাদীয়ে কথা বৰ্তা পতাত আগভাগ লৈছিল আৰু আমাক তেওঁ জনাইছিল। মাটি বেচা বিক্ৰী পাৰমিশন হৈছিল। মোৰ আৰু হৰেণৰ মাটি বেচা কিনা দলিল হৈ গৈছে। He is saying that sealed deal, which is not sealed deal, madam. মোৰ আৰু হৰেণৰ মাটি বেচা কিনা দলিল হৈ গৈছে। মোৰ হাতত দলিলৰ নকলহে আছে। মই মোৰ ভতিজা হৰেণ, জীৱন, দুলন আৰু লক্ষীৰাম বাদী নগাঁৱত থকা ঘৰত আদায় দি কামপুৰত দলিল কৰো। আমি থকা দিবলৈ আহোঁতে মুকুলেও আহিছে। 2 নম্বৰ বিবাদীয়ে টকা বেংকৰ পৰা উঠাই দিম বুলি কৈ উজ্জ্বলৰ লগত বেংকলৈ যায় আৰু আমি কামপুৰলৈ যাওঁ। মোৰখন বিক্ৰী দলিল কৰো। আমি গোচৰতে একেলগে জবাব দিম। আমি গৈ পাওঁতে মোৰ লগত দীননাথো আছিল। 4খন দলিল লিখা হৈছিল। আমি গৈ পাওঁ 3খন দলিল লিখা হৈছিল। কেৱল মোৰখন লিখা নাছিল। বাকী দলিল মই চোৱা নাছিলো, কিন্তু মোৰ নিজৰ দলিলখনে চাইছিলো। কোন তৰণীয়ে লিখিছিল নামটো নাজানো, মানুহজনে চিনি পাওঁ। মুঠতে 4খন দলিল কাৰে যেতিয়া সকলোবিলাক খৰিদাৰ উপস্থিত আছিল। দীননাথ চহী কৰোতে মই চাহৰ দোকানলৈ গৈছিলো। দীননাথে চহী কৰোতে বাকীসকল খৰিদাৰ লগত আছিল নে নাই নাজানো। মোৰ দলিলখন চাই লৈ আহি মই হাকিমৰ টেবুলত পাওঁ। দলিল ৰেজিষ্টাৰ কৰাৰ সময়ত মই উপস্থিত নাছিলো। মাটি কিনা নামত মুঠতে 80,000 টকা দিয়া হৈছিল। মই 10,000 টকা মাধৱ বৰাক দিছিলো। বাকীবোৰ কোন কিমান দিলে নাজানো। দীননাথক মই 14,000 টকা দিছিলো। 24,000 টকাত মই মাটি কিনিছিলো, 10,000 টকা আনপিম দিছিলো, বাকী 14,000 টকা পাছত দিছিলো। মাটিৰ দখল দিওঁতে দিনৰাত যোৱা নাছিল। মুকুলহঁতে বেলেগকৈ দখল দিছিল যদিও নাজানো। মুকুলে কিনা মাটিত খিনিত মুকুলহঁতে হাল বোৱা দেখিছো, দিননাথে হাল বোৱাও দেখিছো। But the caretaker says that he was never given permission. মুকুলহঁতৰ গুচৰীয়া মাটিত ঘৰ আছে যদি নাজানো। দলিলত দিননাথে চহী কৰোঁতে আৰু হাকিমে চহী কৰোঁতে মই উপস্থিত নাছিলো। মই চমন পাই হাকি দিবলৈ আহিছো। মোৰ জবাবত মুকুলে বেংকৰ পৰা টকা লৈ বেংকৰ পৰা উলিয়াই দিম বুলি কোৱা কথা আৰু আমি আমাৰ টকা আদায় দিলো বুলি কোৱা কথা। দিননাথে আমাৰ লগত কাম কৰা সাব ৰেজিষ্ট্ৰাৰ অফিচলৈ আমি তাত এখন দলিল লিখা অৱস্থাত কোৱাৰ কথা। মোৰ হৰেন্দ্ৰ দলিলে তৰণীক লিখিবলৈ দিয়া কথা লিখা আছে নে নাই নাজানো। এইটো সত্য নহয় যে আমাৰ কথা মতে দলিল লিখিছিল আৰু মই মিছা হাকি দিছো। Now your lordship will see the cross. আমি মোকাবিলা বিবাদীগণে বাদীৰ গোচৰত সামৰ্থ্যত জবাব দিছো। 1 আৰু 2 নম্বৰ বিবাদী এটা গ্ৰুপৰ আৰু আমি বিবাদগণে অন্য এটা গ্ৰুপে। 1 আৰু 2 নম্বৰ বিবাদীয়ে 12 বিঘা মাটি কিনা বন্দোবস্ত কৰিছিল আৰু বাকীবোৰজনৰ মাজত 10 বিঘা। মণি আৰু মুকুলে তেওঁলোকৰ ভাগৰ অংশ নিজে দিয়াৰ কথা আছিল। মাটি কিনা বেচা সংক্ৰান্তত সকলো দায়িত্ব 2 নম্বৰ বিবাদী মুকুল হাজৰিকে আগভাগ। দলিল ৰেজিষ্টাৰ হোৱাৰ দিনা মুকুলে নগাঁও ঘৰৰ পৰা দিননাথ বৰুৱা ঘৰলৈ গৈছিল। আমি কামপুৰৰ পৰা আহি মুকুলৰ দিন বৰুৱাৰ ঘৰত লগ পাওঁ। মুকুলে বেংকৰ পৰা টকা উলিয়াই দিলে নাই নাজানো। দিন বৰুৱা 12 বিঘা মাটিত এটা মিয়া মানুহে খেতি কৰে। Now you lost. Kindly see the position of the petition writer, that is PW3. A short one, madam. Sorry.
DW3.
DW3. DW3. Sorry. No. Guluk Chandra Bora. DW3. Guluk Chandra Bora. Original copy to us in the
Yes.
Guluk Chandra Bora. But nowadays we have the advantage, in especially I have seen in Sibsagar court, all these deposition are now typed in as it is. Very easy to read. মই দলিল লিখৰ কাম 1981 চনৰ পৰা কৰি আহিছো। গত 15/5 তাৰিখে মই 1, 2 আৰু 3 দলিল 3খন কামপুৰ সাব ৰেজিষ্ট্ৰাৰ অফিচত লিখিছিলো। এইকেইখন দান দলিল। এইকেইখন দান দলিল। দলিলৰ গ্ৰহীতা মুকুল হাজৰিকা কথা মতে লিখিছো। দলিলৰ গ্ৰহীতা মুকুল হাজৰিকা কথা মতে লিখিছো। তেওঁ আমাৰ কাৰ্যালয়লৈ আহি মোক এই দান দলিল কেইখন লিখিবলৈ কৈছিল। আনজন গ্ৰহীতা ননী বৰুৱাক মই চিনি নাপাওঁ। 15/5/99 চনৰ আগতে মুকুলৰ পৰামৰ্শ মতে দলিলবোৰ লিখিছিলো। দলিল লিখাওতো দিননাথ বৰুৱা যোৱা নাছিল। দলিল লিখাৰ দুদিনৰ পাছৰ তাৰিখটো লিখা হয়। পঞ্জীয়ন কৰাৰ দিনা মুকুল হাজৰিকাই দলিল কেইখন লৈ যায়। যথাক্ৰমে মোৰ চহী। Cross for plaintiff. দলিল ৰেজিষ্টাৰ কৰাৰ দিনা 1:30 মান বজাত দিন বৰুৱা মুকুল হাজৰিকাক পাইছো। দলিলৰ খৰচ পাতি মুকুল হাজৰিকাই দিছিল। মুকুলৰ মই আগৰ পৰাই চিনি পাওঁ, দিন বৰুৱা আগৰ পৰা চিনি নাপাওঁ। দলিল ৰেজিষ্টাৰ কৰাৰ দিনাহে দেখিছো। দিন বৰুৱাই মোৰ সন্মুখত চহী দিছিল। দিন বৰুৱাক দলিল কেইখন পঢ়ি শুনাবলৈ নাপালো। মুকুল হাজৰিকাই ইতিমধ্যে দলিল কেইখন লৈ যায়। দলিলত সাক্ষী চহীও আগদিনা লিখিছিলো। দলিলৰ লিখোতে বিক্ৰীত পাৰ্মিশনৰ অৰ্ডাৰ মোক দিয়া নাছিল। Then the cross for defendant. দলিল সম্পাদন কৰি দিননাথ বৰুৱা। দলিলত মই দিননাথ বৰুৱাক হৈ লিখিছো। স্বজ্ঞানে সুস্থ কৰি এই দলিল লিখি দিছিলো বুলি দিননাথ বৰুৱাৰ হৈ লিখিছো। মুকুলক মই আগৰ পৰা চিনি পাওঁ। পামিলাত মোৰ মাটি আছিল কিন্তু বিক্ৰী কৰা হ'ল। পামিলাত দিন বৰুৱা কেতিয়াও লগ পোৱা নাই। তাৰিখে লিখা বুলি উল্লেখ। এই দলিল পৰা 14/5/99 তাৰিখে লিখা বুলি উল্লেখ নাই। মোৰ দলিল লিখকৰ লাইচেন্স আছে। পাৰ্মিশন নোহোৱাকৈ মাটি হস্তান্তৰ নহয় বুলি মই জানো। এক্সিবিট মই দীননাথ বৰুৱাক কথা মতে লিখিছো তাকে লিখিছো দলিলৰ পৃষ্ঠাবোৰ দীননাথ বৰুৱাই কিনিছিল মই আদালতত দীননাথ বৰুৱাক আৰু মুকুল হাজৰিকাক দেখা নাই লোকে কোৱা মতে লোকৰ দলিল লিখা কাম মই নকৰো আৰু আইন বিৰোধী কাম বুলি মই জানো দলিল কেইখন কামপুৰ অফিচত ৰেজিষ্টাৰ হৈছিল ননী বৰুৱাই আৰু বেলেগ দলিল লিখিছিল যদি নাজানো মোক দিয়া চমনত কোনো পক্ষৰ সাক্ষী মাতিছে উল্লেখ নাই এইটো সত্য যে মই সকলো দলিল দীননাথ বৰুৱা মতে এইটো সত্য নহয় যে মই সকলো দলিল দীননাথ বৰুৱা মতে লিখিলো 15/5/99 তাৰিখে দলিল লিখা নাছিল এইটো সত্য নহয় যে মই জানিছিলি তুমি সাক্ষী দিছো now your lordship will see the deposition of the plaintiff PW1 this is the last one I'm your lordship got it PW1 মই পাতি এই গোচৰৰ মুকুল আৰু ননীৰ ওপৰত মূল বিবাদী হিচাপে কৰিছো মোকাবিলা বিবাদীৰ বিৰুদ্ধে প্ৰতিকাৰ বিচৰা নাই প্ৰতিদ্বন্দ্বিতা কৰিলে একে প্ৰতিকাৰৰ প্ৰাৰ্থনা থাকিল মই মোৰ নিজা স্বত্ব দখলৰ 12 বিঘা গুচৰীয়া মাটি আৰু উক্ত জমি সংক্ৰান্তত হোৱা 3খন ৰেজিষ্টাৰ দান দলিল নাকচ কৰাৰ বাবে এই গোচৰ কৰিছো গুচৰীয়া 12 বিঘা জমিটো মোৰ দখলত আছে আৰু উক্ত দখল সাব্যস্ত ক্ৰমে ডিক্ৰী দিব লাগে গুচৰীয়া জমি গৰুৱাত মৌজা শীতলমাৰী আৰু কমিলাজাৰী কিসামতৰ অন্তৰ্ভুক্ত মুঠ 4খন ম্যাদী পাট্টাৰ অন্তৰ্ভুক্ত উক্ত 12 বিঘা গুচৰীয়া মাটি শীতলমাৰী কিসামতৰ 3খন পট্টা আৰু কমিলাজাৰীৰ এখন পট্টা শীতলমাৰী কিসামতৰ পট্টা নম্বৰ ক্ৰমে 44 আৰু মাটি কালি মুঠ 9 বিঘা 2 কঠা আৰু কমিলাজাৰীৰ 2 বিঘা then those line is difficult I can read from again মাটি আছে আৰু তাৰ ভিতৰত গুচৰীয়া মাটি 12 বিঘা আছে উক্ত 22 বিঘা 3 কঠা 15 লেচা মাটি বিক্ৰী বন্দবস্ত হৈছিল মুকুল নদী জীৱন হৰেণ আদিৰ লগত এই সংক্ৰান্তত মাটি বিক্ৰী চুক্তি আৰু ৰেজিষ্টাৰ বাইনা নামা হৈছিল বিক্ৰী মূল্য 1,82,000 টকা বন্দবস্ত হৈছিল নগাঁও ৰেজিষ্টাৰ অফিচত 29/1/99 তাৰিখে বাইনা নামা ৰেজিষ্টাৰ হয় আৰু মোক 80,000 টকা আদায় দিছিল 1/3/99 তাৰিখে 20,000 টকা দিয়ে মুঠ 1 লাখ টকা মোক পৰিশোধ কৰে খৰিদাৰ 7জন মোৰ একেলগে 1 লাখ টকা দুটা কিস্তিত দিছিল 82,000 টকা বাকি থকা বিঘাই প্ৰতি মূল্য 8,000 কৈ ধাৰ্য হৈছিল 1999 চনৰ বহাগ মাহৰ ভিতৰত বাকি টকা আদায় দি বিক্ৰী দলিলৰ ৰেজিষ্টাৰ কৰা চুক্তি হৈছিল 1/3/99 তাৰিখে পৰিশোধ কৰা 20,000 টকাৰ দলিলখন ৰেজিষ্টাৰ কৰা নাছিল বিবাদী 1 আৰু 2 নম্বৰে 12 বিঘা মাটি খৰিদ কৰিবলৈ বন্দবস্ত কৰিছিল আৰু বাকি জমি 10 বিঘা 3 কঠা 15 লেচা বাকি খৰিদাৰৰ মাজত বুজাবুজিত বিক্ৰীত চুক্তি হৈছিল কিন্তু 10 বিঘা 3 কঠা 15 লেচা মাটি সংক্ৰান্তত কোনো বিবাদ নাই মুকুলৰ নদীৰ লগত বিক্ৰী বন্দবস্ত হোৱা 12 বিঘাৰ মূল্য বিঘাই প্ৰতি 8,000 হৈ মুঠ 96 টকাত ধাৰ্য হৈছিল বাকি থকা 82,000 টকাৰ ভিতৰত 1 আৰু 2 নম্বৰ বিবাদী টকা মোক বিক্ৰী মূল্য হিচাপে দিবলৈ বাকী আছে গতিকে 1 আৰু 2 নম্বৰ বিবাদীৰ পৰাই মই তেওঁলোকক খৰিদ কৰিব বিচৰা জমি মূল্যৰ ভিতৰত 55,000 টকা আদায় পাইছো মাটি বিক্ৰী সংক্ৰান্তে চৰকাৰৰ পৰা ল'ব লগা অনুমতি আদি উলিওৱা আৰু খৰচ আদি খৰিদাৰগণে কৰিব বুলি এই সংক্ৰান্তত ঘূৰা পকা সকলো খৰিদাৰগণে কৰিব বুলি বন্দবস্ত হৈছিল বিক্ৰী দলিল পঞ্জীয়ন দলিলৰ মূল্য আদি সকলো খৰিদাৰগণে দিব বুলি বন্দবস্ত হৈছিল আৰু খৰিদাৰে এই দায়িত্ব বিবাদী মুকুলক দিছিল মাটি বিক্ৰীৰ অনুমতি ল'বলৈ উপায়ুক্তৰ ওচৰত দলিল কৰা আবেদনৰ মুকুলে মোৰ ঘৰৰ পৰা মোৰ চহী আনিছিল মই এনেকুৱা 9খন আবেদনত চহী কৰো অনুমতি পত্ৰ হোৱা বুলি মোক দলিল ৰেজিষ্টাৰ হোৱা দিনাও নগাঁও লাওখোৱা ঘৰত হৰেণ লংকি জীৱন মূলন কৃষ্ণ চুৰেনে মোক জনায় 15/5/99 ইংৰাজী তাৰিখে মুকুলে পিছত আহে দিনৰ 11টামান বজাত জনায় 11:30 মান বজাত গৈছিল তেতিয়া মোৰ ঘৰত লক্ষী বীৰেন জীৱন হেলেন আদিয়ে তেওঁলোকৰ পৰা বাকী থকা জমিৰ মূল্য 81,000 টকা আদায় দিছিল এনেতে বিবাদী মুকুল আহে তেতিয়া লক্ষীয়ে মুকুলক তাহাঁতৰ দিব লগা 41,000 টকা মোক আদায় দিব বুলি কৈছিল মুকুলে তেতিয়া উক্ত টকা বেংকত দিম বুলি কয় নতুন বজাৰ শাখাৰ চেন্ট্ৰেল বেংকত 1-2 নম্বৰ বিবাদী হৈ 41,000 টকা দিব বুলি কৈছিল সেয়ে মোৰ ল'ৰা উজ্জ্বলে মুকুলক লৈ চেন্ট্ৰেল বেংকত আহে আৰু আমি বাকী সকলক কামপুৰলৈ যাবলৈ বাছ টিকেটত আহো কাৰণ বিক্ৰী দলিলত কামপুৰৰ ৰেজিষ্ট্ৰেশ্যন অফিচতে পঞ্জীয়ন হ'ব আমি পাঁচ সিন্ডিকেটত থকা অৱস্থাত মোৰ ল'ৰাই গৈ মোক জনাই যে সিদিনা শনিবাৰে বেংক বন্ধ হৈ যোৱাত টকা ল'ব নোৱাৰি, লগতে মুকুলো গৈছিল। তেতিয়া মই দলিলৰ ৰেজিষ্টাৰ নকৰো বুলি সিদ্ধান্ত কৰো। সেয়েহে লগত থকা আন খৰিদাৰগণে মোকো ধৰাত আৰু মুকুলে পিছৰ সোমবাৰে ২৪ তাৰিখে মুকুলৰ নদীৰ পৰা পাব লগা ৪০ টকা মোৰ ঘৰত দিম বুলি প্ৰতিশ্ৰুতি দিয়াত মই পতিয়ন গৈ কামপুৰ যাওঁ বাছত। মুকুলো উজ্জ্বল মটৰ চাইকেলত কামপুৰ যায় যদিও যাৱতীয় কাম কাজ কৰিবলৈ আমি ২:৩০মান বজাত কামপুৰ পাওঁ। আমি কামপুৰৰ চাব ৰেজিষ্ট্ৰাৰ অফিচত পোৱাৰ আগতে মোৰ ল'ৰা উজ্জ্বল আৰু এক নম্বৰ বিবাদীয়ে কামপুৰ চাব ৰেজিষ্ট্ৰাৰ অফিচত বিক্ৰী দলিলৰ তৰণি হতুৱাই লিখি ৰখায়। তৰণিজনে মই দিছিলো। মই লিখক তৰণিৰ ওচৰত বিক্ৰী দলিলত চহী কৰো। দলিলখন মই পঢ়ি পোৱা নাছিলো, মুকুলো ননীক বিশ্বাস দিছিল। মই লিখক তৰণিৰ ওচৰতে বিক্ৰী দলিলত চহী কৰো। দলিলখন মই পঢ়ি চোৱা নাছিলো, মুকুলো ননীক বিশ্বাস কৰি মই মুঠতে ৫খন দলিলত চহী কৰো। তাৰপিছত দলিলসহ মোক লৈ ৰেজিষ্ট্ৰাৰৰ ওচৰত তৰণি যায়। মোক ৰেজিষ্ট্ৰাৰ সোধাত মই চহী কৰা বুলি কওঁ। মোক এই সময়ত টকা পইচা নাই, ৰেজিষ্ট্ৰাৰ সোধা নাছিল আৰু দলিলখনো পঢ়িও লোৱা নাছিল। ৰেজিষ্ট্ৰাৰ হোৱাৰ পিছত মই গুচি আহোঁ। পূৰ্বে বন্দবস্ত মতে খৰিদাৰৰ সকলো খৰচ কৰে মই কৰা নাই। কামপুৰ চাব ৰেজিষ্ট্ৰাৰৰ পৰা গুচৰীয়া মাতিলৈ প্ৰায় ৯ মাইল দূৰ। তাৰপিছত সোমবাৰে মোক মুকুলে বাকী থকা টকা নিদিয়াত মই মোৰ ল'ৰা উজ্জ্বলক পঠাওঁ মুকুলক বিচাৰি। মুকুলে মোৰ ল'ৰা আগত কয় দান দলিল কৰি দিছে, কিহৰ টকা দিব লাগে। তেতিয়া উজ্জ্বলে আহি এই কথা কোৱাত পিছদিনাই মই কামপুৰৰ চাব ৰেজিষ্ট্ৰাৰ অফিচত এটা এনকুৱাৰী কৰিবলৈ সিদিনা চাব ৰেজিষ্ট্ৰাৰ অফিচত নাপাই বুধবাৰে পুনৰ জানিব পাৰো যে সোমবাৰে সম্পাদন কৰা দলিলৰ ৪খন দান দলিল আৰু এখন বিক্ৰী দলিল। ১-২ নম্বৰ বিবাদী বাবৰে ৩খন দলিল কৰা হৈছিল। মই বিক্ৰী দলিল বুলি চহী কৰো যদিও পঞ্জীয়নৰ ৰেজিষ্টাৰ চাই সেইকেইখন দান দলিল বুলি জানিব পাৰো। তেতিয়া মই চাৰ্কেল অফিচত যাওঁ ১৯/৫/৯৯ তাৰিখে আৰু সিদিনা উক্ত দান দলিলৰ ওপৰত তেওঁলোকে নামজাৰি কৰাই বুলি গম পাওঁ। পিছত মই সেই নামজাৰি নাকচ কৰাও দৰখাস্ত দিওঁ। এই জমিক লৈ এই গোচৰৰ বাধ্য অইন গোচৰো হোৱা নাছিল। ১ নম্বৰ বিপদীয়া মোৰ সম্পৰ্কীয় নহয়। মই ১-২ নম্বৰ বিবাদীক মাটি দান কৰা নাই। বিক্ৰী বন্দবস্ত কৰি বিক্ৰী কৰিছিলো, কিন্তু বাকী থকা ৪০ টকা মোক দিয়া নাছিল। দান দলিল কেইখন মোৰ অজ্ঞাতে চক্ৰান্তমূলকভাৱে কৰাই লৈছিল। মই জানি বুজি দান দলিলৰ সম্পাদন কৰা নাই। মই ১ নম্বৰ বিবাদীক মাটিৰ দখল সমজি দিয়া নাই। মোৰ দখলতে বৰ্তমানো আছে। গোচৰীয়া দলিল ৩খন মই তলব কৰি চলিছো। So this your lordship has said, then the other part my friend has did, but your lordship will see here one line I cannot say. It says that foreigner লক্ষীৰামক in cross বৰাবৰে বিক্ৰী দলিল আৰু বাকীবোৰ কেইখন দান দলিল। আৰু again in cross he again reiterates বাকী খৰিদাৰ গলেও দান দলিল বুলি পিছতহে জানিব পাৰে। And in the last line he says বাকী খৰিদাৰ দান দলিল যদিও মই বিক্ৰী মূল্য আদায় কৰাত আপত্তি কৰা নাই। Now I'll just summarize my submission. There's no problem. For the convenience of the court, I have summarized the point wise. Because so far the third question I have to answer first. The third question was, my lord, whether the learned courts below were justified in bringing the suit in favor of the plaintiff when it is an admitted fact that the plaintiff had duly exhibited that it's specifically described in Schedule Q and the grievance of the plaintiff would have been taken care of by the provisions of Section 55(b) of the Transfer of the Property Act 1882. Then this was framed later on from the earlier question. Now, so far the scope of second appeal, I have relied on two judgments. That second appeal lies on substantive question of concurrent findings by trial and first appellate court that the gift was obtained by fraud and deceit cannot be disturbed unless purpose or unsupported. In this regard, I have relied on two judgments. I have already made that judgments to the court master. The first judgment, the ratio in short is that second appeal is not a third round of fact finding, and the second appeal cannot be entertained to make questions of fact. Now, my learned friend has read section 55(4)(b) of the transfer of property. Why it does not apply, my lord? Because section 55(4)(b) I have said that seller may retain possession until price is paid. Here, my lord, the possession was never transferred. Possession was always on the fire is with the plaintiff, my lord. And here, admittedly, it was a gift deed, my lord. If it is a sale, then 54 Transfer of Property Act would be applicable. And if it is a gift, you also will find 122 of the Transfer of Property Act. In a gift deed, my lord, there cannot be a question of any consideration, my lord. Unless, my lord, sometimes there is consideration like say, the person who lives care of their a person that he may give those consideration are different, my lord, unlike here. And in this court, you'll also find both the concurrent findings are there that this is a fraud committed on the plaintiff. So it cannot be treated as a sin. So I have relied on those two judgments, A is Simratmul and Narendaskar, that where this deals with vendors, clients, and is only on a basis of section 55. Court presupposes a lawful sale. And on the deputy candidate, I have already drawn your lordship's attention that fraud was specifically pleaded in the plaintiff, in the plaintiff, sorry. So I have summarized and I have said that since it is my grievance was fraudulent substitution of gift for sale, and it is not for the unpaid. And they have also not claimed any counterclaim to my claim, or the really short for interpreting. These are all familiar law, just for the convenience of the court, my lord. I have summarized it so that I don't have to. Two thousand four nine. এখন দেখছো 2004 9S. It was reflection. 2004 9 SCC 46. এখন photo 2. Paragraph 12. 2004 9 SCC 468. But in this 2009 4 SCC 468, Palan, I am relying on paragraph number 12.
Yes.
And I'll not read the first line, I'll read page 474, that is parenthesis just below A on the right, 474. When fraud, misrepresentation, or undue influence is alleged by a party in a suit, normally the burden is on him to prove such fraud, undue influence, or disrespect. But when a person is in a fiduciary relationship with another, and the latter is in a position of active confidence, the burden of proving the absence of fraud, misrepresentation, or undue influence is upon the person in the dominating position. And he has to prove that there was fair play in the transaction and that the apparent is the real, in other words, that the transaction is genuine and bona fide. In such a case, the burden of proving the good faith of the transaction is thrown upon the dominant party. Here, the defendant is on the dominant position. In such a case, because all the responsibility was given to him, take out the permission to pay for all those things. It was all even the petition writer also he has arranged it. I had no role to play. I was only asked to come and sign the signature. And all the petition writer and the other witnesses have also supported that it is the defendant who has done everything. A person standing in a fiduciary relation to another has a duty to protect the interests given to his care, and the court watches with jealousy all transactions between such person. so that the protector may not use his influence or the confidence to his advantage. When the party complaining shows such relation, the law presuming everything against the transaction and the onus is cast upon the person holding the position of confidence or trust to show that the transaction is perfectly fair and reasonable, that no advantage has been taken of his position. Another law, but still not. 2006, 5 SCC, 545. I'll not read it, but the relevant paragraph is paragraph 24. This is a familiar law to your law, but just the principle related to section 170 has 100 CPC has been summarized in the judgment. Paragraph 24. Next to 1999 3 SCC, page 722. This is also familiar law, my lord, your lordship, logic, my lord. Only for the convenience of the court, I have cited this just about substantial questions of law. But this, in this judgment, I will be relying on paragraph number 3 to 6. my lord.
This is regarding the principle governing section 100.
Yes. What this judgment, your lordship, familiar law, just to, for convenience sake. also. Then your lordship will see. That's one more. It was a copy.
No, on that point, no further case
Yeah.
law is required.
Yeah.
Not necessary.
Not required.
Any other point?
Just my lord, and since they have not filed any counter claim, so in this judgment only it is said that in the absence of it, there cannot be any direction for refund. my lord.
Yes.
2025 SCC online SC 1014. Air Swiss. In this judgment only I am relying on paragraph 50, where it says that court suo motu cannot grant relief or refund of advance money unless there is a claim.
Paragraph 50.
58. एक मतलब there's a
Okay.
Your Lord, I will just conclude. First, my lord, so far possession is concerned, it is with us. In between, during the pendency of the suit, they also attempted to take possession from us. We have filed FIRs and all. I'm not bringing on the record. Those are other independent procedure, because during the pendency of the hearing in this case also, my lord, they tried to take possession forceful, but in respect of we have filed FIR, that will take its own course. So once possession is there, madam, 55(4) is not applicable. And so far fraud is concerned, we have specifically pleaded fraud in our plaint. And there are two concurrent findings of fact by the court that we have been able to establish fraud on the part of the defendant. Lastly, madam, you will see that it is admitted that all the deeds are gift. It cannot be sale. Because in this type of gift, there cannot be any consideration of money. So we have specifically sought relief for cancellation of all this gift deeds before the court. And the last prayer call, and the prayer call, I have drawn your lordship's attention, madam. So my lord will answer the substantial questions of law. I don't think that to be interpreted with it. Because
Yes, Mr. Mazumdar, any reply?
Well, I not argue anything new, only two submissions, my lord. So far as 55(4)(b) is concerned,
Hmm.
it doesn't speak of possession.
Hmm.
It simply says if there is a transfer, the language is very clear, where the ownership of the property has passed to the buyer.
Hmm.
And for that, my lord, I have relied on the judgment which says that what was the intention of the parties? Intention of the parties was to transfer. Now, in the face of that intention of the plaintiff particularly to transfer, can they now say that no, I will not transfer and I will not refund the money also, I will not transfer also? So section 55(b), application of section 55(b) is not dependent on who is possessing the land. It is on the transfer of the land. There is no question of who is possessing. Rather, it says that your charge is limited to the extent of unpaid price. And the second, my lord, my learned friend has relied on a judgment of 2004 9 SSA 468 to argue that if there is a fiduciary relationship, then the question of the burden will shift. And here in this case, admittedly, there is no fiduciary relationship between the two parties. Fiduciary relationship means, my lord, if the relationship is of father and son, teacher and student, here that fact being not present, that judgment will not apply, my lord. There is absolutely no question of fiduciary relationship. And so far as my last submission, my lord, so far as the fraud is concerned, the whole allegation and case of the plaintiff that there was a fraud will fail only on the ground that he admits that in respect of others, when there is a give deed, I have not challenged because I have received the full consideration amount. That shows that his grievance is not on the nature of document, because his intention is to sell and nature of document is irrelevant for him. What is relevant is the claim for the balance amount of consideration. If that is his case, the whole case, whole allegation of fraud falls through, my lord. Nothing remains in the allegation of fraud. He is not on the nature of the document. He is on the non-payment of the balance amount of consideration. That's my sense.
Just I'll add one. 55B, your lordship, Mr. Lordship, from the date on which position has been delivered. The 55B, the last wording is from the date on which position has been delivered. That is number one. And once we
No, no.
came to know that there was no, that they had made gift it instead of check, there was no intent to sell, and that's why we have not claimed for the balance amount of money. And even on our own independent footing, we have proved fraud, madam.
Well, possibly my learning is not correct. It says from the date of possession in respect of the calculation of interest.
Hmm.
55(4)(b) speaks about possession only for the purpose of calculation of interest, not for the purpose of application of the provision itself.
Okay. Heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr. Hazarika, learned counsel.
P. Hajarika.
Appellant, Mr. B.D. Kaur, learned senior counsel, assisted by Zen Kaur, learned counsel for the respondent. Argument concluded, judgment reserved.
We are blessed.
Obliged.
Coming item 7.
This is a regular second appeal, and at this time there is a delay about 228 days. So notice may go, madam.
Heard Mr. Purkasto, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is prepared by the applicant for condemnation of delay of 228 days in preferring regular second appeal. Let notice be issued to the respondents, be issued to the opposite parties, returnable in for which step be taken by speed post and also by usual process. Okay, now we come to the list after for which
Step by register post.
speed post.
Speed post. Blessings.
For hearing.
Lordship, the other day, from the
Hmm.
previous day, Lordship had asked what is the to be done, whether to remand or to. Yeah, that
Hmm.
kind of.
Hmm. Yes, on the other day, Mr. Khan has referred some of the decision. So copy of the same were furnished to both the parties.
Decision.
Both is for written agreement.
It was written out.
I have to give you all that paper. So my friend is supposed to make argument, lordship on the written statement, argument that I have submitted as a last thing.
Hmm.
And this is one aspect, and another aspect, your lordship was, the lordship tentatively review whether this matter can be remanded to the tribunal.
Hmm.
So this two aspect, lordship, my friend, lordship argue on that one. For market sponsorship, I have done some argument also on a specific point, a remand can be.
Hmm.
My submission will be that lordship, it is not a case of remand because my friend has lordship have missed the past because in view of the Honorable Supreme Court judgment. Because that only CDA 3 where FIR charge sheet is here without challenging or making any complaint on the charge sheet and FIR. So there is no option to open to the company to
rely only on losses, the GDA. So far Supreme Court decision is concerned, I have given the past as losses.
No, maybe, but from the GD entry, it appears that the vehicle who was subsequently replaced is not the vehicle who had met with the accident.
But that was
Then-
lordship,
No, in view of the GD entries, which have been original GD entries, which have been placed before this court, should we shut our eyes and blindly accept your argument?
But so far CDN is concerned, that is,
Hmm?
the claimants or parties have no hand. It is only for the police authority. But the police has, IO has, was examined. He stated that the vehicle was picked up on production. Subsequently, on after going thorough.
No, what presumption?
Madam,
What presumption?
IO said.
No, that's all right. Having got the information, he rushed to the place of occurrence and found two vehicles lying there. Where is the question of presumption?
No, his statement is that he picked up the vehicle on presumption that this vehicle was involved in the incident.
No.
Subsequently, on the investigation found that this vehicle was not involved, other vehicle. So far, the owner and driver of the other vehicle, which is made a property in this case, they have lordship filed a written statement. They did not say that that vehicle was not involved. They have
No,
only-
maybe. There are many such cases.
But if my concise assumption would be that, if there is a pollution, or that vehicle was not in for some another vehicle that has been implanted. Where what step they have taken against the FIR, against the CS? This was based on the lordship on investigation. And the GD entry cannot be supplemented to the FIR. Because FIR and say subsequent lordships are seen.
No, maybe, but the GD entry produced before this court raised a doubt about the veracity of the FIR and the search sheet.
Only on,
And
sure that GD
against the IO concern, case was filed perhaps.
Yes, Lordship, he was examined and he himself said he has brought, when he has gone to the police station and has brought the vehicles. If I may read out the IOGL. I have come to depose my evidence after receiving summon. Exhibit C is the summon. On 7/7/2015, I was posted as traffic in charge in Bongaigaon. On that day, an accident took place at BG Colony and I was informed over phone by Bongaigaon PS OC Dharani Burman. I visited the place of occurrence. An accident occurred with a motorcycle bearing registered number A16A4510. This vehicle was assumed to be hit from backside. The two injured persons were sent to the hospital for treatment by the local public. The motorcycle was taken to the police station for mechanical examination. The injured two persons were Thapara Brahma, aged 20 years, and son of late Abra Brahma, and Bhupesh Chandra Das, aged about 55 years, son of late Makhanlal Das. The two numbers of GD entries were made regarding this accident: GD number 330 dated 7/7 and GD number 334 dated 7/7. These two GD entries were exhibited before the court as already exhibited before the court, exhibit A and B. Exhibit A1 is the name of OC Dharani Burman, exhibit B is the name of Samuel Islam. The B due to other signature of OC Burman. I was endorsed the case for investigation by the OC. Exhibit 1 is the Azhar, exhibit 3 is the charge sheet, exhibit 3(1) is my signature. In my charge sheet exhibit 3, vehicle number AS19H349 was shown as the offending vehicle. As per MBA report, exhibit 5, vehicle number was sent for examination by the MBA. It appears that charge sheet was submitted against the vehicle number so and so instead of vehicle number 451. I have not mentioned in my CS why the vehicles were changed.
Hmm.
He has not given any reason. Then why the vehicle numbers, how the vehicle numbers got there. So see, if I may humbly submit, Lordship, now as per instruction of the direction of the Supreme Court, SITs have been constituted in each and every state, Lordship. And this is also one such matter where the police itself is involved. It can be sent
SIT is constituted.
is in each and every state. This is the direction.
When it was passed.
This the was in 2021. Now SITs they are already functioning, Lordship. I can provide the details. And
Yes, madam, this SIT is available now.
yes. SIT হৈ গৈছে 4 জন আছে এডি যে ভায়োলেট কি লেডি আমাৰ সংযুক্তা বৰপৰা আছে she is the insurance of SIT.
You have to take instruction. Furnish a copy to her.
SIT
That's
is
direction of the Supreme Court.
direction of এইটো সাফিকা এই মই দেখাই দিছো এটি আছে direction. I'll just read out. It is further submitted, having heard the learned council acting on their respective insurance company and the learned acting on their state of UPSI, SIT is assessment, with further direction to may have responsible ministry. It is the printed respective state governments may be directed to consider SIT with respect to complaints of suspicious claims petitions, which may be headed by an officer not below the rank of additional DGP. This is the submission. This is the submission. But already SIT has been constituted in the state of Assam.
Whether it is constituted or not, Lordship.
No, I have that information. It is constituted. There is, no, that is after that.
This is the submission of the council.
তাৰপিছত কৰিছে SIT.
Having heard
I can give you more of him.
the submission of the opinion that before any further direction are issued, no direction is given. We may have the response from the
Ministry,
Ministry
তাৰপিছত আহি গৈছে
of
SIT হৈ গৈছে.
for remedial and preventive measure for curbing the means of filing of false and fraud claim petition. So this is not the direction of the.
No, SIT has already been constituted. Regardless, the SIT has been constituted in the state of Assam. I'll give you the details. Even
Submission made by the parties. This honorable Supreme Court has
হৈছে না SIT হৈ গৈছে.
made an opinion to the Ministry of Transport to have their suggestion for remedial. This is.
Notification issue হৈ গৈছে. SIT notification মই দিব পাৰিম.
But Mr. Goswami, that is one of the way of issuing direction while disposing of this appeal.
Yes, Lordship.
But what about the claim then made in this appeal?
That's been too complicated.
Remand back the matter to the tribunal, Lordship, and directed to that the owner of the other vehicle, Lordship.
Okay.
Can be summoned to produce in both the owner, Lordship, in both the vehicle, Lordship.
If the operating vehicle in the case was, they submitted their initial statement. They did not deny that their vehicle was not in. In their written statement of the OP number 2 and 3, para 9, your lordship.
Anyway, first they will obtain inspection as to whether SIT is constituted or not. So will you fix it on Friday or Monday? Monday. Heard Mr. Argusami, learned counsel for the petitioner, no, for the appellant. And Mr. M. Khan, learned counsel for the respondent, number 1 and 2. And also heard Mrs. D.D. Burman, learned senior government advocate for the respondent, number 5. During the course of deliberation, Mr. Lusami, learned counsel for the appellant, submits that pursuant to an order of the Honorable Supreme Court in the case of, what is the number of that case?
Citation to vehicle. Lordship, 2021 STPL
The
12177
parties,
SC.
name of the parties.
Never Safik Ahmed versus ICICI Lombard General Insurance Company.
Reported in Reported in
Reported in Lordship, I have the STPL citation, 2021 STPL 12177 SC.
Okay. The state government has already constituted one special investigation team. And direction may be issued to the said special investigation team to investigate the present matter also. In view of the submission of Mr. Dusami Learned, counsel for the appellant, Ms. D.D. Burman Learned, additional senior government advocate, is directed to obtain instruction as to whether such SIT is constituted in Assam or not. List the matter on Monday as part heard.
Wait, please, Honor. The conducting advocate has to go to the school due to some urgency. Can it be adjourned today? I pray for adjournment
You are praying for adjournment.
for today.
Okay. Yes.
On 27th, if possible. On 27th of this month,
27.
7th.
Friday. This is hearing matter.
Any other?
Only on hearing date.
On 10th March, is it possible? 10 March. 10 March.
10th of March. Okay. Heard Mr. Cabra, learned counsel for the petitioner, and Mr. J. Dr. Learned counsel appearing on behalf of Mr. A. Soduri. Learned counsel for the respondent number 3, 4, and 5. Mr. Cabra submits that due to some he has some inconvenience today, and the matter may be adjourned till 10th of March.
10th of March.
10th of March. They are allowed. List the matter on 10th of March. Okay. Yeah, you are for the respondent.
Yes, my.
Appellant is absent today.
They will not count current.
Okay.
It is a fraud.
So we are dismissing it for non-prosecution.
It is a. This case was filed against us earlier. So that filed against Manishu loan, the loan. First party landed 5 lakhs loan to the second party, respondent. But actually it was not true. The plaintiff filed this case falsely to grab the property.
Okay, we are dismissing it.
But if we go to the judgment of the lower court, that is.
No, madam, we cannot dispose of this matter on merit.
Actually, my lord.
We'll dispose of it due to non-prosecution.
The defendant will 85 years old, pending from the 17th.
No, maybe we are dismissing this appeal.
Pardon?
We are dismissing this appeal today due to non-prosecution. None of is for the appellant on call. How about Miss? Your name, please?
Rituja Dr. R. Dr.
R. Dr. Learned
Legal
Legal Aid Counsel for the respondent is present. It appears that the appellant remain absent on 21/8/2025 and 1/4/2025. Today also the appellant remain unrepresented. And in view of above, this RSA stands dismissed for non-prosecution. Interim order, if any, passed earlier, stands vacated. Recess shall return the record of the learned courts below forthwith.
70.
I'm responding here, madam.
Where is the petitioner?
70.
17.
May it please your lordship, my senior is on leg. So kindly the matter may be taken after some time.
After some time.
Yes, lordship.
Item 4 question is item 1.
May I please lordship. My lord, earlier we approached before this honorable High Court and your lordship passed an order, kindly see page 30. Operative portion lordship may kindly see page 33, para 10 onwards.
So whether you have been given an opportunity of being heard there?
Yes, the hard means the persons went there in my absence. I was also present, but I was not called on. So I went there. Now, lordship, in that CRP, your lordship, because there is serious differences in the boundaries. And for instance, my lord, the writ petition lordship may kindly see page 14. I am satisfying your lordship. Kindly see page 14, bottom. North Soburuddin Sheikh, South Solimuddin, East PWD Road, West Solimuddin Sheikh. Now they want to execute the decree totally in another boundary. Can you see first 14C and then 38, 38 bottom. In the main suit,
Mr. Mahmood, you see, after the order of this court, the trial executing court has appointed one commissioner.
yes,
Commission.
yes,
And the commissioner has visited the place
yes,
and submitted a report.
yes.
And the report, finding of the report is reflected in the order. in the
Order, yes, yes.
So what wrong with that finding?
Totally wrong, my lord.
How?
I am showing this because your lordship ordered that if the disputed land is identifiable
Identifiable,
by
yes.
DAG number and patra number, then it can be also executed. No dispute is there. So we are on that because no appeal is filed, so that order has become final. Now they want to execute the decree. Now kindly have a look to page 38. Page 38 and 14 or your lordship may also see page their petition, page 42. 42 and 38 kindly see. 42, they have given the boundary of the land which they want to execute, North Umedali. Here, lordship, you can see in their petition, North Soburuddin Sheikh, their petition. So, South, my lord, here, Johurul Haq, here, South is Solimuddin. And East, my lord, Aminul Haq, and here, East is PWD Road. And West, PWD Road,
here West Solimuddin Sheikh. So your lordship was on the view that even if there is disputes in boundaries, but if the land is identifiable on the basis of patta number and dag number, then decree may be also carried out. So on the basis of that, 38 plus 38 petition was submitted and totally giving a separate separate boundary. But thing is this, kindly see, there patta number is, my lord, rightly given. But now patta number is given, patta number, lordship would see, page 42. Patta number, dag number 42, kindly see, their petition, it is their executive, this title execution case. 42, here, my lord, the village Rakhalia 254, 255 and patta number 94. But now both the dags have been changed, patta number has been changed, there is also no dispute. Newly it is changed, but dispute is here that the new patta number lordship may kindly see now 47. Earlier patta number was 94. Now it has become 136. Lordship has seen 47. It has become now 136. And earlier dag number was 254, 255. Now dag number has become 292, 293. Page 47. Lordship has seen. But here is the name of Zolibur Rahman. In the report, it is said that all the lands are in my possession. Yes, that is true. But Zolibur Rahman is my uncle, own uncle. And Zobeda Khatun is my own mother. And Zohrul Haq is I myself. And now Fazar Ali's name is there. So 3 persons' names are there. 3 persons were uncle, mother, and I myself. Now kindly see, here is land. Total land is 3 katha 16 lesa plus 2 katha 1 lesa. That means 1 bigha 17 lesa.
No, Mr. Mahmood.
I am satisfied, lordship.
No.
3 bigha 16 lesa
No.
and 3 katha, not bigha. 3 katha 16 lesa.
Mr. Mahmood, you see, the direction of this court was whether the suit land is identifiable on the basis of this dag number and patta number.
Yes.
And the trial court has held an executing court after appointing a commission and on the basis of the report of the commission held that yes, it is identifiable. Now, what wrong with the impugn
Wrong,
order?
lordship, kindly see, 5 katha means 1 bigha and 16 plus 17 lesa. 1 bigha 17 lesa land.
No, Mr. Mahmood, we cannot reopen the matter while dealing with an application under
And
Article
where is this?
227.
No, my lord. I do not want to say to reopen. But total land is 1 bigha 17 lesa.
No, we will not go into that aspect.
But he claims 1 bigha land.
No,
Where is
no,
those 1 bigha land? Kindly.
Only we can direct the executing court to execute the decree as per the decree passed by the trial court.
Trial court, yes. That I also want, but they are not doing that.
No.
Here, my
Only
lord,
that
kindly see.
direction we can issue. We cannot reopen the matter.
Lord, 1 second, please. Here the names of several persons are there. Total land is 1 bigha 17 lesa.
That is the responsibility of the
There is
executing court.
No, my lord. There is no where mentioned that Fazar Ali has so many land and Zohirul Haq has so many land.
The direction of this court was to whether it is identifiable on the basis of dag number and patta number.
My submission, kindly consider my case. Total land is 1 bigha 17 lesa as per the report of the commissioner. And Fazar Ali wants that my land has been occupied by them 1 bigha. If 1 bigha is taken, then only 17 lesa remains. 17 lesser remains. But nowhere it is written that in this DAG number, new DAG number or old DAG number or new DAG number, new pattern number, old pattern number, there is nowhere written that Fazur Ali has 1 bigha of land. I have
No,
occupied.
no, we will not go into that.
Lordship has understood my point.
Sorry.
My submission is that.
Sorry.
And we are also the patta holder of that.
Strictly in accordance with the decree.
Strictly, yes. Strictly in accordance with the decree, without interfering my own land.
No. We will not pass any such direction. Strictly in accordance with the decree.
Decree?
Provided it is identifiable on the basis of DAG number and patta number. So that will be the order passed by this court. Nothing more and nothing less.
My,
We will not go into who is in possession.
but
What is
land
the
is
total
only
amount of land?
17 lesser land. And nowhere it is written so
No,
and so
maybe.
have this, everybody has share, but share is not written.
Okay, we are disposing of this petition with
May
this
I
petition.
propose one submission, my lord, that the Mandal will say the which persons have how many lands in this DAG number and patta number.
Hmm.
Because our land they cannot take it. They will get the decretal land.
Decretal land, yes.
Decretal land.
Yes.
But a decretal land should be identified
On the basis of DAG number and patta number.
DAG number and patta number.
Hmm.
But here is no mention is here that Fazur Ali gets 1 katha or Zohirul Haq gets 1 katha. There is nothing written.
Okay, as per the decree. Okay. Covered. Okay.
And my lord, that is fixed day after tomorrow.
Okay. We are passing the order today.
Obliged.
While this matter was called at 3:20 p.m. One counsel appearing for the petitioner submits that the conducting counsel is on leg. Mr. Ziuddin. No, and there was a pair for taking up the matter after some time. Mr. Ziuddin, learned counsel for the respondent present. While the matter was again called at 3:25 p.m., the petitioner is found absent. The counsel for the petitioner is found absent in the court premises. No, in the court. However, Mr. Ziuddin, learned counsel for the respondent present, leaves the matter after a week. Maybe what to do? I am ready to hear.